Good morning, good morning, good morning, Law Nerds. Today we are here to take a look at the Adelson case. There was a brief hearing yesterday. There is jury selection starting today. There is lots that we need to do. So that's what we are going to be doing today. We are using our new streaming software. So if things look a little different or seem a little different, it's because we are using our new software. So it's time today to roll the intro to go to court because, well, as I said, there was a hearing yesterday and then there is the beginning of jury selection today. So with the beginning of jury selection today, the judge is going to tell the jury the charges and the instructions, and we'll go look at that. Not much of consequence, knock on wood, is going to happen today, but we're also going to go over, for those of you that are newer to the Adelson case, we're going to go over her charging documents. They're pretty substantial, and it will give you an overview of what the prosecution thinks they're going to prove about this case. We'll do court first. We're going to go over new motions. We learn a lot more about these jailhouse informants because, well, it says redacted, but not as much as redacted as last time. Remember last time we went over this motion, I was just like, hello, redacted, redacted, and redacted. So we learn more from this motion because there's stuff that's not redacted. I downloaded that just in case it was an error. I was like, oh, that's more than we got last time. Let's take a look. And then Wendi Adelson's motions that were heard yesterday as well. So we have yesterday court, today court, and a bunch of court documents to get through in the Adelson trial that starts really today. And they actually started jury selection today. So we might be in trial. We might actually be in trial. I know, who knew? Because the last time this was supposed to go to trial, like a year ago, we were just like, we thought that was going to start trial. And then all the attorneys got kicked off the case and now we're here. So are you guys ready? Are you ready to go to court? I'm ready to go to court. So let us roll the intro. We're going to kind of kick the tires on all the new stuff. And well, then we're going to go to court. So let's roll the intro. Let me find my intro real quick because I've got things compressed in a weird way. So, you know, new things. Who this? All right, let's go. Nope, that was me. See? New things. Still me though. Like just still me. See? Look, and now it's supposed to be rolling and it's not. It's a good time. All right, well, I guess the intro is just like we don't want to do that today. Let's see if we can swoop it. That's going to have to work. That's just going to have to do it because our intro just doesn't want to roll, which is very strange actually, because streaming is dynamic. I don't even know what to tell you guys. See it. No, it's sure not going to go. So, that's a party and a half for us. Can I figure out why? No. Nope. We got the swoop. We had it for like a fraction of a second. But that's a new issue. So party on. You know what we're going to do instead? We're going to fly to Florida. We're just going to fly. So why not? It works. You guys know who I am. We're flying to Florida. Let's go to Tallahassee, shall we? We need to just get into court. So what we're going to do first is look at court from yesterday. We will go over those motions in a little bit. So some of the stuff I'm going to pause and explain from yesterday's court. Some of it, well, we're not going to need to explain. It's a fairly short hearing from yesterday. Then what yesterday being August 18th, 2025. Then we're going to go to court today. Then we're going to go to motions. Sound good? Sounds good to me. So let's go to our hearing from yesterday. And then, well, we'll take it from there. But look, we can just we could just go to court. I know, you guys, it's so good. Let me move the closed captioning, which is actually pretty good. Let's go over our hearing from yesterday. Look, we're going to go to court. We're not going to have any hear ye's, but hear ye, hear ye, hear ye. Ladies, gentlemen of the chat, all y'all of the chat, we are going to court in Tallahassee for Florida versus Donna Adelson. This court has seen this case go to trial, not with Donna, but with everybody for like 10 years. Donna Adelson is charged with murder, conspiracy to commit murder, and solicitation of murder. This is a hearing from yesterday. Let's do it. Emily, just do a brief road so far. We're going to do a thorough run through of this case after we do court. Here's a real quick TLDR. Donna Adelson is charged with murder, conspiracy to commit murder, and solicitation of murder of her ex-son-in-law. Her daughter, Wendi, with an I, was going through a child custody battle in Tallahassee. Donna and the rest of her family were in South Florida, Miami area. Son, Charlie Adelson, was I think, periodontist, but a dental specialist who is, convicted now of murder, conspiracy to commit murder, and solicitation of murder. So he's in custody out of state, just got transported back into state to come testify in this trial, but in prison for all of those things he was convicted of almost 2 years ago now. He is convicted of arranging the go-between who was dating him and worked at his dental office, and she arranged a driver and a hitman who murdered in 2014 Dan Markell, a beloved law professor and the father of Wendi Adelson's children. Custody battle. The custody battle was heating up. It looked like Wendi was going to lose the motions before the court that would allow her to bring the children to South Florida. The kids were going to stay in Tallahassee, and Dan Markell was murdered in 2014. The driver pled and is in federal custody. The gunman was tried and convicted. The go-between was tried and convicted, appealed, tried again, convicted again. Charlie was tried and convicted. His appeals are still pending. Then Donna was arrested after Charlie was convicted. That is going to factor into this trial in a very big way because a lot of this trial is digital, and the shit that Donna said on the phone is going to be hugely relevant in this case. And there's some more argument of her shit that she said while she's in custody. So she got arrested. We played it here. We went through the arrest. She got arrested on like the jetway to get onto a one-way ticketed flight to Vietnam and had been talking about the fact that they were a non-extradition country. She is going to testify at trial. We heard that last week. What's she going to say at trial, Emily? Oh, she's going to say that she didn't know any of this and people were blackmailing her. That's what Charlie argued too. And that she is just, she is just, none of those conversations mean what those mean prosecutors are saying that they mean. And that one-way ticket was just because Vietnam is lovely. And I mean, I haven't been, I'm sure that it is, but it was just, she needed some relaxation because life was so hard after her son was convicted. And that doesn't explain why she was on the jail call that was recorded talking about this being like her plan B was to flee. So it's going to be an interesting trial. We'll talk more about all the digital evidence as we get into it, but let's go to court from yesterday one more time. Emily, you're having too much fun with the streaming software. I know I am. But you guys, the sound is going to be so much better. Here's something I never thought I would say. If it's too loud, tell me, and we will adjust. I know.
I believe we have everyone that is necessary for the hearing at this time. Parties may make their appearances on the record.
Georgia Kappelman and Sarah Catherine Dugan for the state.
Joshua Zoman and Jackie Fulford for Mrs. Adelson.
Good afternoon, Your Honor. John Rollo on behalf of the witness.
Okay. John Luero on behalf of Wendi. The fact that closed captioning knows that Wendi Adelson's name is spelled with an I is beyond to me. But the audio sounds like the attorney on Zoom swallowed the entire potato microphone. That is the attorney on Zoom. Everyone else sounds okay. We're just going to roll with it. That's Wendy's attorney on Zoom.
Adelson, and my colleague Matthew Luca is with me as well.
Good
Lucas.
afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm.
That's before Wendy
your client
testifies.
As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor. No position.
Does the defense have a position?
Yes, Judge.
Go ahead.
Wendy, let me pause this a little bit better because now it's like action blurred.
May I-
Wendi Adelson's attorneys made a motion to quash a subpoena from the defense. Remember, quash means squash, get rid of, crush, remove. So the defense, Donna Adelson, Wendy's mom, through their attorneys, made a motion to subpoena Wendi into court to testify from or for the defense. Wendy's attorneys made a motion and said, so what we're not going to do is that. And we would like this subpoena yeeted out the window. We're not going to comply. Remember, Wendi is also subpoenaed by the prosecution. But when Wendi is subpoenaed by the prosecution, the things that she testifies to in court can't be used against her in any subsequent prosecution if there is a subsequent prosecution of her. So there are protections when she is a state's witness. There are not protections if she is a defense witness, and they're going to get into that.
Stay here.
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been two prior rulings in the homicide of Mr. Markell. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct.
That generally...
This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she
I love
can be
this, Judge.
cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know if we call
That's a
her,
problem.
she could rebut what has been said. It's not necessarily, it would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and
Ma'am, I understand you're doing your job, and I'm glad you're doing your job. But she's testified multiple times already. There have been multiple trials. I don't know what you expect to come up that hasn't come up already. But I appreciate the defense's argument. The defense argument being, hey, if she's one of the first witnesses, shit might come up and we might need to recall her. If they recall her, she's just going to plead the fifth. And that's the problem that they are stuck in.
credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes,
Yeah.
Your Honor.
Hold on, Mr. Lawyer.
He's asking the defense attorneys in court, counsel, not defense attorneys on the phone. So he's asking the defense attorneys in court, look, you didn't respond to the defense's argument, to Wendy's attorney's argument. What's your response to their argument?
I'm going to allow Ms. Fulford.
Oh, I'm sorry, I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
Susie in the chat said, so why not call her at the end of your case? It's not up to the defense attorneys. The defense attorneys are saying the prosecution's going to call her early on. So if things come up, we can't call her back to the stand. Right, because they can't call her back to the stand. So the defense wants to be able to recall her on their subpoena, but they can't because she'll just plead the fifth, and you can't call someone just to plead the fifth. So that's where the defense is frustrated about wanting to call Wendi.
So the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't.
Right.
But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
So
From the perspective of your client,
the relationship to your client's not what's relevant. Terry said, can't they just question her on cross? They can question her on cross, but the cross is limited to what's brought up on direct. And the defense's argument at the beginning of this hearing was, if things come up as the trial progresses, we should be able to call her again to testify. And that's not what's going to happen. Amanda said, why is her attorney on Zoom and not in person? I don't know where her attorney is, but this was a fairly last minute hearing. It might just be that her attorney is not in Tallahassee. Florida's a real big state. So who knows where in the state of Florida, like where in the world is Carmen Sandiego? I don't know. Where in the world is this attorney? The attorney might not have been in Tallahassee, and this hearing got put on calendar like same day. So it might just be a factor of not being able to drive that far that fast.
certainly understand the argument you're making. Mr. Lauro, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanawa trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
I know that Wendi Adelson, daughter of Donna Adelson, sister of Charlie Adelson's attorney, sounds like he has eaten the deep fried potato microphone. I know that's exactly what it sounds like. Here's the sum and substance of what he said, and we'll go over this motion a little bit. That is the attorney on Zoom that is hard to hear. Wendi Adelson's attorney, Wendi is going to be a witness in this case, is arguing that during the McBanawa trial, she is the go-between. The second trial, after it went up on appeal and she got a new trial, the Court of Appeal found that quashing the subpoena for Wendi was proper. So even though there was a second trial, these decisions were previously upheld. So if the Court of Appeals was already like, yeah, this is fine, this judge isn't going to change that ruling when it's already been fine. So Wendy's attorney is saying this has worked before. This is what the courts found was proper. The defense cannot grant any type of immunity. If Wendi chooses to testify under a defense subpoena, anything she says in court can be used against her. If she is testifying under a state subpoena, They cannot use it against her in criminal or any proceedings, what she says in court. It doesn't mean they can't use other things against her, but they can't use what she says in court. So the defense's option is cross-examination, and that's about it. So let's continue on.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on concerning the subpoena and quashing the subpoena, Ms. McBanawat did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler
And these are
followed the
Donna's
proper
defense
procedure.
attorneys.
My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further,
We don't have tag team motions. Who's going to finish the argument?
One horse, one rider, and one rider, one horse. Like you can't ride two horses with one ass. So no tagging in. Is the judge a wrestling fan? Your Honor, I have questions. What do you think of? No, we're not asking him about the Paul brothers. Your Honor, I've got questions. No tag team. Linda D in the chat immediately said, tag team back again. Check it to wreck it. Let's begin. Potty on, potty people, let me hear some noise. DC's in the house, jump, rejoice. Look, I can't remember where I put my laundry. I know every damn word to that song. Every single one. Let's continue.
Just a moment, Your Honor.
No tagging in. No tagging in.
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanawat would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the court's rule should be done on a question-by-question basis.
Nope.
So your expectation is for me to ask the question. She will make some sort of signal. I'm invoking the juries to be removed, and then we
Go question
do
by
this
question.
for the entire defense direct.
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor, the statement by counsel is patently incorrect.
The judge said last word and then I will rule. And this is Wendy's attorney via Zoom. We know what the court's going to do, right? The court's just like, this is not my first rodeo. The defense can't call someone to the stand for the purpose of them pleading the fifth. You can't do it. And the defense can't offer immunity. So, no.
False. This issue was raised by Ms. Carras in the McMonaghan trial. She preserved the issue. She made the same arguments that these
This is
defense
Wendy's
lawyers
attorney.
are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There's simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
All right. Having reviewed the applicable authority on this,
The court's going to rule. Here's what Donna's argument was. But Your Honor, that's our client's daughter. We can ask her more questions because we know her better. Y'all, this is going to be incredibly interesting when Wendi testifies. Incredibly interesting.
issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject. I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right, I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the
He's quashing the subpoena. I'm going to grant the relief that's requested. Chanty asked, is there tension? There seems to be, based on some of the recorded calls, there seems to be some tension. Rachie said, has Wendi been on trial? No, she's testified, but she has not been charged in this case. And she's testified under the state subpoena. Kim asked, what can she testify to? She can testify to whatever the state asks her under the state subpoena and what she's asked on cross that are proper questions. The defense can't call her as a witness because the defense can't offer her immunity.
defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time. But I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laurel, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well.
Good day, sir.
That concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this point.
So that is the end of yesterday's hearing because the rest of it was done in camera, which is sealed. The in-camera portion, generally it means like in chambers or sealed, but the court cleared the courtroom. So if it's done in open court, it can be done in open court. It's still a sealed proceeding. So that is what was happening yesterday. I will go through what I think the sealed proceeding was about because I have that motion, but we're going to go to court today from the things that were happening today before we get into all the paper motion. IR Miklet, I think, said, is Wendi's immunity general law or only given on a case-by-case basis? Wendi is given immunity under the rules in Florida because it is a state subpoena. It does not work everywhere that way. But when the state subpoenas her, she has essentially use immunity, which means they cannot use, in this circumstance, the things she says in trial against her if they were ever to prosecute her. It does not stop them from using other evidence, other statements, but what she says in court under the state subpoena to testify cannot be used against her in the future in any way. Under a defense subpoena, there is no such protection. The law does not allow for it. So she has limited immunity that extends only to the things she says in court when subpoenaed by the prosecution. She could choose to testify for her mom. She's choosing not to. And any lawyer is going to tell her, you only testify under the state subpoena because otherwise it's off the table. So the defense can't do anything to offer immunity because the defense can't bind the prosecution into an agreement. The defense can't bring a prosecution. They can't offer to not bring a prosecution. Only the prosecution can offer that type of immunity because the defense isn't in a position to prosecute. So let's see. If she ends up testifying, can it be used as impeachment if it's different than what she testifies to? If she testified in a different trial, you can impeach between the trials, but if she went to trial on her own, no, you can't. So let us continue on. Kim said, EDB, who are you most looking forward to seeing testify? I'm interested to see this entire case. We know Donna Adelson's going to testify. I'm interested to see if things change because of who the defendant is. So I'm interested to see if the testimony is different because there seems to be some tension here. So before we get into court from today, we do have a stream sponsor today, and I am going to thank our stream sponsor. You hear me talk about them just about every month because A, I love Incogni, and B, I use it very frequently because it's running all the time in the background. So I could say I use it daily. but also because they have a great deal for the law nerds. So, for today's stream sponsor, Incogni, thank you, and we will be right back. A huge thank you to today's stream sponsor, Incogni. Well, that completely froze, so that's not what I anticipated. Don't worry, we've got it in two places because somehow it just didn't want to roll the way we wanted it to roll, which was super fun for us. So we're going to get to do a take two. But don't worry, we've got a take two. And our sponsor, Incogni, knows that we have new software. So they can put up with all of our shenanigans. So a huge thank you to today's sponsor, Incogni. A huge thank you to today's stream sponsor, Incogni. Incogni is the service I use to help remove mine and my family's information from the internet. One of the big causes of this is data breaches that are seemingly unending. And as I was sitting down to record this, I am seeing breaking information that Pandora Jewelry sent out emails to all of their customers in early August because their company fell victim to a cyber attack exposing all of their customer data, everything from email address to home address, shipping address, and possibly payment information. And everyone is still trying to clean up from the breach that hit Apple, Google, and Facebook. You know that your data is out there and you don't have time to submit takedowns to every single one of these sites. And it is a constant monitoring that's needed. And that's exactly what Incogni provides. And Incogni has saved me personally over 818 hours. If you're ready to make some of your cyber protection a little easier, Incogni has got you covered. And of course, we've got a discount because you're law nerds. Just use code EmilyDBaker at incogni.com/EmilyDBaker to get an exclusive 60% off an annual Incogni plan. You heard me correctly, 60% off an annual Incogni plan with code EmilyDBaker, or go to incogni.com/EmilyDBaker and start saving some money and saving your private data. And honestly, saving yourself a ton of time because there are streams to watch and court to discuss. So let's get back to it. And back to court. So, law nerds, thank you, thank you, thank you. And thank you to our stream sponsor, Incogni. We are going to go to court from today. So we're going to go to court from today. It's jury selection. It's not going to be that much. Jury selection is not streamed. There are streams up that show the seal of the state of Florida because there is no audio and no video. But because there are cameras in the courtroom, we have the initial jury instructions that the court gives to the first set. The court is bringing in groups of 50 in the morning and in the afternoon. And then we have reading of the charges. If anything consequential happens during jury selection, then I will be sure to send you an alert in the Law Nerd app if that happens when we are done streaming. I expect jury selection will take a few days, but if jury selection is done today, tomorrow, the next day, they're going to go right to opening statements. So all of you have said, Emily, when are opening statements? I don't know. Opening statements are when they're done with jury selection. So whenever jury selection is done, that's when opening statements will be. So grab the Law Nerd app. It's free. We will keep an eye on the feeds and let you know. But we're going to go to court from today. Take a look at, well, the basic instructions that the court gave. And then we will get into all of the filings that are recent and into more of the Jailhouse informants. And then we will do a full reading of the charges against Donna, because Florida put everything in their probable cause statement in their PCA. So it's pages and pages and pages. I know all of you are like RIP only fan. I don't even know if the courtroom has a fan. They just keep going to the seal. So let's pull up court from today.
Bring the jury.
It's time. It's time.
Bring the jury.
The jury is there. I mean, they're not the seated jury, but the jury is there. I'm very excited. So let's go to court. Shall we? We shall. We're going to. This is, well, the initial instructions. I know, RIP to the fan.
I'm going to read to you at this time a statement of the case that has been agreed upon by the parties.
Can you just imagine? You get called into jury duty. You know nothing about this case. You're bopping around in your life, doing all the shit you need to do. It's August. You get called into jury selection and you're like, it's going to be fine. And then the court reads you this.
On July 18th, 2014, FSU College of Law professor Dan Markell was shot while seated in his car. This happened in the driveway of Markell's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markell. She has entered a plea of not guilty. The statement of the case that I've just read to you is not evidence, and it's not to be considered by you as evidence or any proof of guilt. You must not be influenced by this statement. It is merely informing you of the accusation that has been made by the state against the defendant. Before we speak with you individually and privately about this case,
y'all, I know all of you are like, who takes a Prius? Look, from all the allegations I've seen, they had to drive from like Miami area all the way up to Tallahassee. It seems like that's a long drive. I mean, you're going to save on gas. So yes, a Prius in 2014.
Some of you may be excused. Mr. Zellman, you can take it. I'm also going to read to you at this time the material part of the indictment that has been filed against the defendant. Once again, the indictment is not evidence, and it's not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. It is alleged in count 1 that on or about July 18, 2014, Donna S. Adelson in the county, Leon, and state of Florida did unlawfully kill a human being, Daniel Markell, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markell, contrary to the Florida statutes. Count 2. Beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanois and or other persons to commit first-degree murder, contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanois, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markell, contrary to the Florida statutes.
So that's the reading of the
I
charges?
believe I said this before, but we are now going to speak with each of you individually and privately about this matter. Some of you may be excused during this process. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time-consuming, but will go a lot smoother if you are prepared to tell us what we need to know.
It is very
The basic
time-consuming.
questions that you will be asked are the following. Number 1, what do you know about this case? Number 2, what sources have you obtained this knowledge from? Number 3, based on
Have you heard of this case? Do you watch YouTube? Do you listen to podcasts? Do you follow the local news? What do you know? How do you know it?
what you know, Do you have an opinion about Mrs. Adelson's guilt or innocence?
What do you think of Donna?
Number
huh?
4, can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be fair and impartial? Number 5, do you have any reason that you cannot serve on this jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these 5 questions and you are prepared to give a prompt answer when you are called back.
I really appreciate, no, I'm going to keep doing it. I appreciate that the judge told them what they would be asked so they could think about it, so they don't go individually and go, okay, wait, what? I appreciate that the judge gives them that heads up so that they are not caught off guard. And he also reminds them, look, we're in jury selection. We got the first 50 people here. Not everyone is going to stay. Some of you will be excused. It just normalizes it. So it's not weird when somebody gets excused. It's like, ooh, what did they do? It's like, no, some of you are going to get excused. So that's fine. That's what we expect, that some of you will get excused. He lays the groundwork of expectations really well with the jury, and I appreciate that. Oh, that was the very end. I paused. Wait. I could have just let it end. I wasn't paying attention. I could have just let it end. But the court gave the jurors the expectation, the charges, a brief overview of the case, and then told them a little bit about what the individual voir dire process will be. The individual voir dire process is going to be jurors one by one. Why? Because what you don't want, and this is me just making something up, for example, but you don't want a juror to sit there and be like, yes, I have listened to podcast, news, newspaper, YouTube, nightly news about this case. And yes, I have formed opinions about Donna Adelson. And I also have opinions about Wendi, Your Honor. Let me tell you what. And then that individual just in front of the entire courtroom and everybody is like, I think she's guilty. I think that one's guilty. I'm glad these were charged. I know that Charlie's in prison. What else do you want to know? Because then the rest of the jurors sitting in the courtroom are like, ooh, tea. But it's information that they may not learn throughout the course of this trial. So you do it one by one so that the jurors can tell the court honestly what they know about the case without everyone else hearing it, because once the shit's out of the horse, there's nothing you can do. So that's why they're doing individual voir dire, especially in a high profile case, because some people are going to know about this case and you don't want the other jurors that don't know, because now they know. Like if you don't know, now you know. Now you know. So they try to prevent it from infecting the rest of the jury pool with information that they don't otherwise have, because they are looking for jurors who don't know much about this case, or like, oh, I think I might have heard that when it happened, but I haven't really followed it. Wasn't that in 2014? I don't know. A lot of shit's happened between 2014 and 2025. Like I don't know. Those are the type of jurors that they're looking for, because it's not that you can't know about the case. It's that you can't have formed an opinion about the case. So if you heard a thing, then you heard a thing. Let's get to the rest of the instructions that the court gives to the jurors, and then I'm going to answer some questions. IR, I hope I pronounced this properly the last time. IR said, how was the end date 2 years after the murder? When the court was reading the charges, and when we go over the charging document, you'll see this again, because the conspiracy was ongoing. Conspiracies don't necessarily end when the crime ends if part of the conspiracy is to continue to evade detection and or arrest. So the dates for the conspiracy to commit murder extend well beyond the murder date because it's a conspiracy charge. Donna is charged with murder, conspiracy to commit murder, and solicitation. Conspiracy and solicitation are different. You can conspire to murder someone without like soliciting someone to do that thing. You can conspire with people to do that yourself, or to have somebody within the group do that. And everybody's like, this is how we're going to do it. Montel Jordan is in my brain. It's not appropriate, Emily. Rein in the lyrics for a moment. But if you are soliciting someone else to do it, that solicitation is a separate charge, different than conspiracy. All right, let's get to court for the initial jury instructions. And again, jury selection is starting today. It's anticipated that jury selection will last 3 or 4 days in this case, and that the court is going to start opening statements once a jury is seated. They are seating 12 plus 3. So once you have that many, then the trial is going to start. If that takes today, it takes today. If it takes multiple days, it takes multiple days. So we're just going to see. I'm going to keep an eye on it. And that's why I said I'll keep an eye on it and let you know in the app. All right, let's go to court.
Respective jurors, I should say, are on their way.
Kratzy B said, damn, this trial snuck up on me. Same.
Do they meet the
Same.
criteria by statute?
Same.
All right, bring them up. I'll just address them when I get here.
3 or 4 days of jury selection is not unusual in a high-profile case.
Yes, sir.
Just wanted to discuss the statement of the case that you did today.
This happened sooner in time than the last part we read, but I wanted to go to the statement of the case first. So this is just the lawyers lawyering in court. We jumped around a little bit. So this is the lawyers and the judge talking before the jury comes in.
Just the indictment that is actually.
Wise Bliss said, why did he say, and the county, Leon, and state of Florida, they didn't have anything to do with this? Non-lawyer Lawnard, thank you. Because the conspiracy and solicitation didn't happen in Tallahassee. The murder happened in Tallahassee, but the solicitation all happened elsewhere. Those are the jurisdictional elements because you have to prove that it happened within the jurisdiction. So within the county and the state. So that's why it says it in the charging docs.
Been filed, yes.
Well, I'm referring to the statement of the case of the jurors. Think about what question you're asking them.
Oh, yes, go ahead.
So statement of the case is what they're all talking about. We're going to go over the charging documents later.
Just bring the transcript up.
It's fine.
Last week, we were talking about why do lawyers print so many things out? This is why. Walking up to the court with your computer is not necessarily what you want to be doing. And it's just like, here you go, Your Honor, take my laptop. It's going to be fine. Just here you go.
Just the questions that are highlighted.
And the statement of the case started on the prior page.
Creekside Casual said, if the conspiracy was perpetrated in Miami, why would it be tried in Tallahassee? I know the murder happened there, but the conspiracy was planned in Miami because the murder is also charged, and the murder happened in Tallahassee, and Tallahassee charged it.
Okay.
You're not going to separate the murder from the conspiracy charges, and anywhere within the state of Florida can be tried. Miami doesn't want to try this. It is a Tallahassee case. That's where the murder happened. And that's where the other cases have been tried as well.
Trying to save when this was given.
This was in Charles.
Right. But at the point in which it was given.
Sal in the chat said, if Donna gets found guilty and Wendi is charged, will Donna testify against her?
Please.
And there's a lot of ifs, and there's a lot of things that have to happen before that. But I don't know if they're ever going to prosecute Wendi. They haven't yet. Maybe it's because they want her to testify in all these other trials. We'll see.
Did they not come up with the rest of the group?
The court's waiting for all the jurors to come up. I appreciate that the seal of Florida is so colorful. The seals in California, in all the courtrooms I worked in, were just like embossed, but they were not colorful. This is very colorful for a seal.
Okay.
I appreciate it.
Okay. Are they?
And it doesn't say the great state of Florida. It is the great seal of the state of Florida instead of the seal of the great state of Florida. So the seal itself is great. Interesting way to modify the seal. But the seal is pretty. So no only fan, but we definitely get the seal.
14 in there, everyone else
So
over there.
Florida.
Everyone can be seated.
We're going to get to the jury instructions. Thank you, Miguelina, for editing this so I don't have to zoom.
Tricia, once numbers 2 and 15 have been located, they're just to be seated in the back. We're going to move forward with what we have right now. Good morning, ladies and gentlemen.
Good morning.
Okay, not great. Listen.
The jury is going to like him so much. The jury is going to like him so much. I'm going to back that up because he jokes with them already. Like right out of the gate, we've got the judge joking with him. Let me roll that back one more time.
Have been located. They're just to be seated in the back. We're going to move forward with what we have right now. Good morning, ladies and gentlemen.
Good morning.
Okay, not great. Listen, I'm giving you a proper greeting, looking you in your eyes. All I'm asking back from you is for the same. Good morning, ladies and gentlemen.
Good morning.
There we go. I'm Stephen Everett, one of...
Ladies and gentlemen of the jury, can we be more excited about being on jury duty? They're like, no. He's like, one more time with feeling. More passion, more energy, more passion. Come on, everybody. We're in court. Let's go.
Of your circuit judges for the Felony Criminal Division here in Leon County. You have been summoned here.
The Tallahassee County. We'll go back to the charging document and talk about jurisdiction when we get there. Do not worry. Emily, your familiarity with Florida. I know, we've barely had a case in Florida, and it went so fast with Judge K.
Greeting, looking you in your eyes. All I'm asking back from you is for the same.
I like this.
Good morning, ladies and gentlemen.
Good morning.
There we go. I'm Stephen Everett, one of your circuit judges for the Felony Criminal Division here in Leon County. You have been summoned here today as prospective jurors in the case of the state of Florida.
They're going to walk away
versus
liking
Donna
him.
Adelson.
No matter what happens
This is
with this
case
jury, they're going to
number
love
2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection. Ladies
and gentlemen, welcome to court for jury duty. This is a murder case. And everybody's got to be like, wait, what?
Process today that I will be reading to you. It is not that I do not wish to have a normal or free-flowing conversation, but rather any explanation that you receive on the law during this process must be uniform and it must be specific according to the Florida Supreme Court.
Yeah, gotta.
Is the state ready to
do
select a jury in this matter?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that Mrs. Adelson is present in the courtroom with her counsel. I believe downstairs a few minutes ago, you spoke with Judge Ashenofi Richardson, where she went through the qualification process with you concerning who is actually eligible to serve as a juror in the state of Florida. What I'm going to do, just to make sure that anyone at this point would otherwise qualify to be excused by statute, I'm just going to confirm this information. By a show of hands, is everyone who has been brought up this morning at least 18 years of age or older? Please raise your hands.
Can you even serve?
Record all prospective
Everybody's
jurors
over
have answered in
18.
the affirmative by
No
raising their
17-year-olds
hand.
by accident. Great. Perfect.
Are each of you citizens of the United States of America and residents of Leon County, Florida? Please raise your hands if this is so.
You must
Again,
be
for
local.
the record, the prospective jurors have raised their hands in the affirmative. Are all of you residents of Leon County? Please raise your hand if this is true.
Awkward
Again,
Cali
the
girl
prospective
asks,
jurors
so a
have
person
raised
can be
their
charged
hands.
with murder
Thank you.
regardless of if they committed
Do
the actual
each
murder?
of you possess
Yes.
a driver's license or identification card that's been issued by the department?
We can get into aiding and abetting later, but yes, you can aid and abet a crime and conspire to commit a crime and be charged with the underlying crime. Sentencing, depending on statute, can overlap a little bit. If you're convicted of all of them, you can't always stack the charges on all of them. But yes, if you are convicted of conspiracy to commit murder, you can also be charged with and convicted of the underlying murder.
Of highway safety and motor vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Please raise your hands. Once again, for the record, the prospective jurors have raised their hands in the affirmative. The next series of questions are basically just going to deal with whether anyone should be excused at this point or is ineligible to serve. Has anyone been previously convicted in a state or federal court of any felony crime or a crime of dishonesty, and you have not had your rights restored to you?
So he's going
If
through
this
show of
describes
hands
your situation,
for the
please
entire
raise your
jury
hand.
panel of 50. He's going to do this every time
For
they
the
bring in a
record,
new
none of the
panel.
prospective jurors have raised their hands. Are any of
These
you
are
at this time
statutory requirements.
under current prosecution for any crime, either in a state or a federal court? Please raise your hands if this describes your situation.
Generally, if somebody falls into
Once
any of
again,
these
for the
categories,
record, none of the prospective jurors.
if anyone falls into any of the categories he's reading, that will generally come up in the jury room and they will be excused. But the court is making sure on the record for any future appeal that this is all handled. So generally, if the answer is yes to any of these, it comes out on a questionnaire and you're not called back into court. So it's very rare that you would see somebody raise their hand in court to this because they would have already put it on their jury questionnaire, not been called into court.
Jurors have raised their hands. As to matters in which you can be excused by law, is any person here a sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response to the court's questions. Is anyone an expecting mother or a parent responsible for the full-time care of a child under 6 years of age?
Not all jurisdictions excuse full-time
So,
caretakers from jury duty. Some jurisdictions do. Some jurisdictions are like, figure it out. It's, I think, preferable if you were the full-time caregiver of a child under 6 that you just be excused from jury duty until that child is over the age of 6. But not all jurisdictions do that. Some are like, can you figure it out? Figure it out. So it really just depends on jurisdiction.
That is, please form a line and I will deal with you momentarily just in the middle.
So
Is anyone present 70 years of age or older?
different jurisdictions have different ages for this as well about whether or not they
No hands
excuse
have been
you
raised in
over
response to this
70.
question.
And some people can say, no, I want to
Has
stay.
anyone performed state jury service within the last year? And by last year, what I'm referring to would be August 19th, 2024 to today.
Allison said, interesting
hands
that
have
pregnancy excuses you would make it an interesting trial if someone went into labor during trial. The problem is, as interesting as it might be for all the deputies to be like, they're going into labor, it could cause a mistrial if you're already out of alternates. So they don't want to deal with that at all. Nope. Also, I don't know how everybody's pregnancies were, but for me, there's no way I could sit through trial. I had a really hard time doing trials when I was pregnant, but that's a very long story for another day. I was not the usual. I was we see that in about 1% of cases. I'm like, great. I love that being me. I love that for me. I love it.
Raised in response to that question. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and your presence will create a hardship. No one has responded in the affirmative to that question. Is anyone a full-time student between the ages of 18 and 21
You guys
years
have
of age
great questions.
who is
I'm
attending
holding
a
on to
high
them.
school, state university, private post-secondary educational institution, Florida college system institution, or career center?
Sarah Juror
Right, if you
13
please can
said,
stand behind the gentleman.
I'd have family watch my
in
boys. I want to
aisle.
do jury duty so bad. And the court will often give people the opportunity to say, I can accommodate for this. I am the primary caregiver, but it's not a hardship. And so you can also tell the judge, no, I want to be here. So
I believe we also have one new one by statute. Has anyone given birth within the 6 months before the reporting date on your summons, and you are seeking to be excused for that reason?
and that's the question, seeking to be excused.
No hands have been raised
Right.
in response.
You guys have great questions.
One
I'm
by
holding on to
one,
all
if you
of them.
please can come forward, and I will address the issue in which you responded to your questions.
All right. And that was the screening process for jury duty. So they are taking groups of 50, screening them down with the initial questions, and then going into individual voir dire. So we heard the screening questions, and then we heard the court give the explanation of the case and then get into one-to-one individual voir dire. So a lot of you are saying that you're having some issues with YouTube. I don't know if restarting will help. But if you need to do that, this has been going on for a couple of days. I've had some viewing issues depending on whether I'm on mobile or my phone. So on our end, things are looking great, but I apologize if you are having that issue on the other end. Sadly, I would love to have control of things, but I don't. We are going to go through the charging documents for Donna Adelson with like the 6-page breakdown of the evidence in this case. We're going to go through Wendy's motions. We're going to go through the Jailhouse informant motions. There's a new one from Friday. I'm very interested to see that, but we have a few questions about jury service that I'm going to answer real quick. And then we're going to get into all those documents. So let's see. Frankie Bean asked, Emily, did you prefer one-to-one or as a group when selecting a jury? I imagine one-to-one takes more time. It does take more time. Not all cases need one-to-one voir dire. In the cases that I did, we generally did group voir dire, and then there were particular sensitive issues that we did at sidebar one-to-one. So there will be times when you will ask if anybody has been a victim or has someone in their life that has been a victim by crime that might make it hard for them to sit on a particular case once they find out what the case is. There was a period of time where I was doing a lot of DUI related homicide cases. Unfortunately, lots of people have had their lives touched by DUI, but you also don't want that to infect the rest of the jury with sympathy for what that person had been through. So a lot of personal experiences shared at sidebar where people are like, look, any other case, but but not this. And people explain, mostly for the appellate record, what their personal experiences were. So we would do those things one-to-one, but we would do a lot of group voir dire. But the thing I like about group voir dire is you can get an idea for people's personalities in a different way about how they choose to interact in a group or not. And you can get a different sense of how they interact with you as the attorney. But California gives a lot of room for voir dire and for the attorneys talking directly with the jury. Other jurisdictions give substantially less. So I'm familiar with what I know, but it's nice to see if the jury will listen to you. If you already have some jurors who are like, your voice annoys me, your face annoys me, why are you wearing glasses? It's just time for them to go. It's like, this is not a vibe. And sometimes you can feel it. So it really just depends. But we did a combination of both. I'm going to get to a few more questions I saved. Emily 101 said, during law school, I got summoned for jury duty twice, both times during finals. And I imagine the court was immediately like, no, you need to go. Come back later. We'll see you. We'll see you later. Do not worry. Chronic Shock asked, question, if they've served in the past year, are they allowed to stay if they still want to? It's going to depend on region. And I imagine some of it will depend on how jurors are paid, but it's also going to depend on the judge if they have them stay. Jill said, can released felons do jury trial? I mean, they can always go to trial if they're charged again, but I'm assuming that's not what you mean. They can serve on jury duty if they've had their rights restored. If they have not had their rights restored, then they cannot serve on jury duty. Kim says, EDB, do you miss trials? No, I get to do them all the time here. Do I miss doing them? No, it's very stressful. I like to sleep. Janica said, is it difficult to be excused from jury duty in the U.S.? It varies by judge, by jurisdiction, and by case. If you are looking at picking a jury on like a 3-day case, most judges are going to be like, you can do anything for 3 days. Come on, it's going to be fine. It's going to be fine. If you were looking at a 4-month case, there are going to be more things that release you during trial. So it very, very much depends on a lot of different factors. Pizza Driver said, Emily, when does jeopardy attach during a trial? Now or after the jury is impaneled? After the jury is impaneled and sworn is when jeopardy attaches. So once they've picked 12 plus the alternates and then sworn all of them in, that's when. Let's see. Hazel Leaf said, question, Emily, do you have to take some sort of test to become a judge? I know it's often an elected or bestowed, but do you have to meet requirements? Generally, there are requirements for how long you've been an attorney. Not all locations have requirements for how long you've practiced, but you have to generally be a licensed attorney in good standing. But I've seen people be elected for judge that have never actually like practiced law. I'm like, why would you want to do that? That seems real stressful. But no, there's not some kind of test you take. But in different jurisdictions, there are different committees that review judges and give them ratings for their temperament and knowledge of the law, and their colleagues will help inform that. It just depends on each jurisdiction. But yes, you have to be a lawyer in good standing. I don't know a jurisdiction where you can be a judge and not be an attorney in good standing. It's possible, but I don't know. So let's see. Xyz341 said, question, can a jury member during trial decide they actually can't emotionally, mentally stay for the rest of the trial? Does that excuse them? I've never seen it, I don't think. We covered something similar in the appeal in the Russell Lafitte case, where he was arguing that one of the jurors felt that the deliberation process was too aggressive and didn't want to continue with the deliberation process. And the court was like, you have just as much of a say as anybody. Get back in there, essentially. And then said that the individual could be excused at the end, if I'm remembering it correctly. But generally, the court will encourage someone to stay. But if someone's like, I'm out, you've got rights of the defendant to consider. If somebody says, I can no longer be a fair and impartial juror, it's a problem. What I find is by the time most people get into a case, they have a camaraderie with their other jurors. And even if something might be uncomfortable, they're like, no, I take this seriously. I want to be here deciding it. Generally, by the charges, people opt out if they need to opt out when the charging happens. Marie asked, question, is it possible Wendi got some kind of behind the scene deal? It's not possible that Wendi got a behind the scene deal. The prosecution would have to disclose that to the defense. It would upend all of the prosecutions if that had happened, which this prosecution team seems incredibly conscientious, so I don't see that being the case. Wendi gets immunity for the testimony given in court under the state subpoena, and that's it. There's no other deal, or you would hear about it on the record and she would be questioned about it when the defense started cross-examination. Let's continue on. We need to go through the documents. So let me pull those up. We're going to go through the charging document first, and then we're going to go through the jailhouse informant document and Wendi's motion, which is going to be a whole thing. So let me pull this up and we will go to the charging document. So buckle up. For those of you that are familiar with this case here, I'm going to put up a poll real quick. Let's see. Let's start a poll. Are you... I'm just going to ask your familiarity with this case. Yes. I know it's fascinating watching me type. I'm sorry. But if I talk and type, I'm going to lose my train of thought and then I'll never get this poll up. Let's see. And I want to get this poll up. And fourth option. I'm just going to see how quickly we need to go through this because I wanted to get a sense for, well, how familiar you may be with this case. So we're going to go through the charging document. It is 24 pages long. We will go through most of those pages. So if you do not have a snacky snack yet, it might be time to grab said snacky snack because we are doing all the things. So let's pull up the charging document and get to getting on reading this. Look at that, you guys. Where's my applause? It just look. It's just so easy to see. I love it. I love it so much. I think you guys can see it. I can see it. I am so happy. This charging document and statement of offense and probable cause is from November 13th, 2023. We are going to go through the charges. We are going to go through the statement of probable cause. We're going to do all of it. Victoria said, how long are charging documents normally? Not this long. This is a very fulsome statement of offense. There is a lot in it. So buckle up. We're going to go through, oh, I didn't swoop. We're going to go through all of it. We need a swoop too. Hold on. Wait, that's not what I was looking for. Swoop. We swooped. A nameless musician said, stop doing crimes on my birthday. No, it was just the arrest date. That was the date she was traveling. That was the date that she was arrested in Miami. She was ready to go to Miami. No, she wasn't ready to go to Miami. She was ready to go to Vietnam. All right. Statement, summary of offense and probable cause, charges first-degree murder, conspiracy to commit first-degree murder, solicitation to commit first-degree murder. The affidavit sets forth the probable cause to believe that Sigfredo Garcia and Luis Rivera murdered Florida State University law professor Dan Markel, and the murder was arranged through Catherine McBanois, Charles Adelson, and Donna Adelson in violation of Florida statutes, murder per chapter 782. It hurts my brain, actually, when homicide charges aren't 187s. It just, look, Cali too long. It's so hard for me that other statutes aren't also 187. It's just, the code for murder is 187. It just confuses me. 782. So, Sigfredo Garcia Rivera, and McBanois and Charlie are all in custody for this crime. All of them have been tried and or they pled and sentenced. So, on Friday, July 18th, 2014 at 11:02 a.m., a report of a shooting was received at the location home of Florida State University law professor Dan Markel in Tallahassee, Florida. Upon arrival, Tallahassee State police officers found Markel slumped over the driver's seat of his vehicle from an apparent gunshot wound to the head. Markel was transported from the scene to the local hospital where he later died from injuries sustained during the shooting. He died the next day, is the best of my memory. The investigation of the crime scene found no indication that this incident was part of any other criminal intent, such as burglary or robbery. A neighbor heard a loud bang and looked out the window where he saw a small silver or light-colored vehicle resembling a Prius backing out a victim's driveway. He walked over to check on Markel, discovered him in distress, and called 911. Fucking terrifying for that neighbor. Like, you hear something, you see something, and then you're like, holy shit. Investigators located victim's ex-wife, Wendi Adelson, at a local restaurant and transported her to the Tallahassee Police Department for an interview. During the interview of Wendi Adelson, she made statements suggesting the murder of Markel could have been arranged by someone on her behalf without her knowledge. It's a weird thing to say in a police interview when you're told that the father of your children has been shot in the head in his driveway. It's just a weird thing that the first response is, oh, somebody might have done that for me. Okay. It's a weird statement. Wendi indicated her parents were very angry at Markel and further suggested that someone could have arranged the murder thinking it would help her. She specifically mentioned that her brother, Charles, aka Charlie Adelson, joked about hiring a hitman to kill Markel in the past. She said her brother makes a lot of jokes in bad taste and had previously commented that he looked into hiring a hitman, but it was cheaper to buy a television as a divorce gift. Wendi indicated that she did not think her brother would actually commit this crime, when in reality, her brother now sits in prison after being convicted of, in fact, committing this crime. You know, you have a right to remain silent. And she just went the opposite direction of like, I mean, somebody might have done that for me. Like, I didn't ask them to, but like, they might have done that for me without my knowledge. My brother's been saying, I mean, he was going to hire a hitman. Weird. Wendi indicated that she did not think her brother would actually commit the crime. It should be noted that Wendy's mother, Donna Adelson, set a television repair appointment on July 11th, 2014 for Wendy's television to be repaired on the morning of the homicide, July 18th, 2014. You're telling me that Donna Adelson set like a Geek Squad appointment at Wendy's home for the morning of the murder. Donna set a TV repair appointment. I really wonder if the TV needed repair. Like, do we have the records? Don't tell me if you know from Charlie's trial. I want to be surprised. I'm asking in hyperbole. I want to know. But did her mother set up an alibi for her? So Donna sets a TV repair appointment at Wendy's house for the morning of the murder. Tell me Donna didn't know what was going down again? Donna. I didn't know it was happening. Girl. Real interesting, Donna. Real interesting. Records obtained from Best Buy show a service was completed on her television the morning of July 18th, the same date as the homicide. Wendi stated that after the divorce, she wanted to relocate to South Florida with her children. She felt her former in-laws would suspect her of murdering their son since she was denied the ability to move in court. LB in the chat said immediately, "What if I told you I'm a mastermind. Look, I can't sing all of T Swift, but the T Swift reference is on point. Lyndon said, and Best Buy was like, ew, Donna, who pays in cash anymore? And this smells like mildew. For those of you new to the case, that will make more sense in a minute. The prosecution is going to have such a good time. Not a good time. It is a murder case. But when you're a lawyer and arguments that are toothy land in your lap, arguing that Donna set up an alibi in the light of Donna likely testifying that she was blackmailed and she knew nothing about this is going to be real interesting because Donna set the appointment. And that's just the tip of the iceberg. I'd forgotten about that, honestly. And then Wendi, it continues being chatty with police because, she's a talker. Wendi stated that after the divorce, she wanted to relocate to South Florida with her children. She felt that Dan Markel's parents would suspect her of murdering their son since she was denied the ability to move by court. Well, the prosecution now agrees. Lona said, wait, why does the appointment matter? Because Donna set up an appointment on July 11th for July 18th. Dan Markel was murdered on July 18th, seemingly at the same time Best Buy was at Wendi's house, but Donna arranged it in advance. Donna's going to say she has no idea about the conspiracy to commit murder and she doesn't know about these hitmen yet. 7 days in advance? She set up an alibi for her daughter and she didn't know what was going down? Interesting. That's how the prosecution's going to argue it. Wendi filed for divorce on September 10th, 2012. The divorce was later finalized by marital settlement agreement on July 31st, 2013. Investigators reviewed voluminous documents, including emails, texts, and court documents. The review determined Wendi Adelson and her brother Charlie, as well as their parents, Harvey and Donna, were determined to have Wendi and the two Markel children relocate to South Florida, where the Adelsons reside after her divorce from Markel. Markel objected to his ex-wife moving his children to South Florida. And on June 20th, Leon County Circuit Court Judge Hobbs formally denied with prejudice Wendi's motion for relocation with the children. So the prosecution is going to argue that what was going on in the divorce case was a substantial factor and motive for what happened here. After the court's denial, Wendi's parents, especially her mother, Donna Adelson, repeatedly tried to convince Wendi to coerce Markel into allowing the relocation to South Florida. Donna suggested the family offer Markel $1 million to allow relocation, with Donna Adelson and her husband Harvey Adelson contributing a third, Wendi contributing a third, and Charlie contributing a third. First of all, everybody just has $250,000 chilling. That's not a quarter, that's a third. $350,000 chilling. We'll all just pitch in, you guys. We'll go like halvesies. We'll just give him $1 million. Like, let your children move and we'll give you $1 million. Dan Markel doesn't seem to be persuaded by money. And what's interesting to me is Dan Markel was, by all accounts, a brilliant legal scholar, had gone to Harvard Law, had gone to Harvard undergrad. I am sure any firm in the US would have snapped him up and paid him a actual boatload of money, just all the money, just all infinite money. He chose to be a professor. Choosing to be a professor is something that people are driven to do, not by money. Anyone in education, let me know in the chat. It meant more to him than that. So offering him $1 million to have his kids live, 8 hours away? Doesn't seem to be the play here. When you want to be a professor, you want to be a professor. You're not going to leave your job. Anyway, they thought $1 million would about do it. And Donna suggested that Wendi threatened to convert Markel's children to Catholicism, knowing Markel was very observant in his Jewish faith, and that the religious practices of his children were of utmost importance to Markel. It's just fuckery. Like this guy, weaponization of religion. Like, I'll convert the kids to being Catholic. What the fuck? This trial is going to be interesting. Wendi Adelson's prior boyfriend, Jeff Lacasse. It just reads Lacoste to me, and I know that that's not right. Wendy's prior boyfriend, Jeff, stated Wendi disclosed to him that Charlie had seriously looked into hiring a hitman in the summer of 2013, and he was told it would cost either $15,000 or $50,000. Ex-boyfriend reported that when he was visiting Charles Adelson with Wendi in the spring of 2013, Charlie bragged about being connected to a Cuban criminal element. Jeff, good on you for telling the cops whatever. Okay, those of you that watch prior trials, are we going to see Jeff? Is Jeff going to testify? I know it's not a spoiler. Is Jeff going to testify? Thank you, everyone who has seen this trial already. Vis-a-vis Charlie, all of you said yes. Oh, boy. Is Jeff, my name Jeff, is Jeff the one who drives a Prius, chat? Like of the similar color? Yes. Oh, boy. Oh, boy. Also, who's telling... Was this Wendy's boyfriend after the divorce? Oh, Jeff. Jeff was like, this family is up to some fuckery. And Charlie would brag, look, here's the thing, Charlie. We're just not legal advice. But just here's the thing. Like, people who are actually dangerous, don't brag about being dangerous. You know why? Because they're fucking dangerous. They don't need you to know. They don't need to tell you. The only people who brag about like having friends that are criminal are people who don't know anything at all. It's such posery bullshit to be like, I know people who are criminals. What, did you have a patient who has a record, Charlie, in your dental practice? Aren't you a periodontist? Nobody's even talking to you when they're coming in to see you. Miss me. Emily, the periodontal shade coming out of nowhere. It's just fucking true. The most terrifying gang members that I had an opportunity to speak with, who weren't even the most terrifying ones out there, were incredibly pleasant to me as a DA. It was like, everybody's got to do what they got to do. We all got our own jobs, but they're not bragging about their status within the gang. They don't have to. Everybody fucking knows. They don't talk about it. But Charlie trying to flex just indicates that Charlie doesn't know anything. Stop being such a poser, Charlie. I know people who are dangerous. Shut the fuck up. Just shut the fuck up. All right. Just miss me. I'm not shading all periodontists. Shade for Charlie. Well, maybe not shade for Charlie, because I mean, he did do this well enough to get himself pretty easily convicted. How long was the jury out on Charlie? A couple hours? It was learned that around the time of the murder, Catherine McBanawa was involved in a personal relationship with Charlie. McBanawa's cell phone. Look, I would normally redact this, but McBanawa's in prison. That cell phone number is not hers. She's the one who Charlie bought boobs for, apparently. We'll get there, I'm sure. Calls show that McBanawa was one of Charlie's top contacts in text communication, confirmed the relationship was more than a friendship, because they had all the text. It was later confirmed by Catherine that Charlie Adelson enlisted her, who then enlisted the father of her 2 children, Sigfredo, to carry out the murder. So Catherine's dating Charlie and went to her baby daddy and said, hey, I mean, I can picture it was, hey, these dumb rich people want to pay you to commit a murder. Let's just take their money. That's just my speculation of how that phone call went down. But she asked the father of her children to help carry out the murder. Garcia enlisted Rivera's assistance, and McBanois, Garcia, and Rivera were compensated for their actions. McBanois was the only link between Markel and the shooters, Garcia and Rivera. McBanois' only tie to Dan Markel were Charlie Adelson's and a couple instances where she met Wendi Adelson. The only way McBanois, Garcia, and Rivera knew Dan Markel and his relationship with the Adelson family was through Charlie. While in the interview room, Wendi wanted to call her parents to notify them of the incident. While contemplating aloud as to what she would say, she told the victim advocate sitting next to her that her parents were very angry with Markel and described it as a very fucked up situation. Those rooms have video. I imagine that we'll see it. I imagine that we'll see the video. Wendi then called and talked to her mother, Donna. After notifying Donna of the shooting, Wendi asked her to notify Charles of the shooting so Wendi would not have to do so. After Wendy's conversation with her mother, Donna called Charles' cell phone at 7:11 p.m., which went to voicemail. Charles called Donna's cell phone at 7:13 p.m. with a call duration of 5 minutes, 47 seconds. At 7:29, Charles called Donna again with a duration of 6 minutes, 31 seconds. At 7:36, Charles called McBanois with a call duration of 2 minutes, 49 seconds. Wendy's parents, Harvey and Donna, made contact with the lead TPD investigator at Markel's memorial service on Sunday, July 20th, 2014 in Tallahassee. Oh, that's my wedding anniversary is July 20th. Fun facts. But they've got all of the phone records, right? So they know who's calling who and when. The Adelsons agreed to contact Tallahassee PD to arrange for an interview before returning to South Florida the following day. TPD investigator contacted Wendi on her cell phone, and the investigator identified himself. Wendi claimed to have a bad connection, and the call was terminated. I can't hear you. I can't hear you. I'm sorry. I'm cutting out. Click. My speculation. I have a bad connect. I can't. Are you there? Are you there? I can't hear you. We must have a bad connection. Oops. Less than 5 minutes later, Wendy's attorney called the investigator. Wendy's attorney called the investigator. You had good enough cell to call your lawyer. Yeah? No shade though. I mean, the right thing to do is to call the lawyer. Just tell the investigator you need to contact my lawyer. Yeah. After that initial interview, you definitely need a lawyer. Wendy's attorney called the investigator to inform him that Wendi left town with her children and parents en route to South Florida. The attorney could not provide a date for Wendy's return to Tallahassee and requested he be contacted for any further inquiries. When is she coming back? No, she's not. No. Patty in the chat asked, is the jury seeing all of this? This is what the prosecution expects to show in testimony. Without my dramatic asides. But yeah, they will have witnesses for this, which is going to be interesting. And some in the chat have been incredibly kind and restrained because a number of y'all watched Charlie Adelson's trial. I have not. We have not. Maybe we will down the road. But we're going to be watching Donna's trial as the first of these trials. But a lot of you have already watched Charlie's trial. So I appreciate the, yes, this person will testify, no further spoilers. It's a tightrope and you guys are doing amazing. So Harvey and Donna Adelson left Tallahassee with Wendi and the grandchildren the day after the memorial service without speaking to the investigator as promised. Sure, we'll chat. Bye. Since leaving, no one in the Adelson family contacted Tallahassee PD or inquired about the status of the investigation. Charles Adelson did not attend the memorial service for his ex-brother-in-law. In July of 2015, Wendi had the children's surname changed from Markel to Adelson. I don't know if the jury will know that part. Maybe. I have thoughts about it. I'm going to leave those be. I have feelings. 20% of you in the chat say this case is new to you. So I'm glad we're going over this. On July 18th, Markel left his home, drove his 2 children to daycare on the west side of Tallahassee, drove to Premier Health and Fitness, arrived at Premier Health and Fitness, where surveillance video shows a silver or light green Toyota Prius enter the parking lot after Markel parked his car. After Markel went into the health club, the video captured the Prius in the parking lot where the driver moved the vehicle to a different parking position while Markel was in the building. No individuals ever exited the Prius. Additional surveillance video discovered for the day of the homicide showed the same Prius before and after the homicide, including following Markel into Markel's neighborhood immediately prior to the shooting. It's like they went and pulled video. Canton could never. This is 2014. They have video surveillance from the gym. They have video in the neighborhood. After analyzing the surveillance videos, the suspect vehicle was determined to be a 2006 to 2009 Toyota Prius with silver pine mica print color. The Prius had tinted windows, a sun pass transponder on the top center of the windshield, a missing tow hook cover on the front bumper, and a black passenger side mirror casing. The sun pass transponder is going to be linked to an account. It's going to show everybody where you travel. They track your travel. It was determined the Prius followed the victim throughout the morning and back to his residence where the shooting occurred. The suspect vehicle fit the description given by Markel's neighbor after he heard the gunshot and looked out the window and saw the Prius backing out of the victim's driveway. Florida Department of Transportation records for SunPass on Alligator Alley, I-75 west of Fort Lauderdale on July 16th and 18th, 2014, had one account listing a Prius as a customer vehicle. The SunPass transponder activity was consistent with cell site data for Rivera and Garcia's handsets travels. So they pulled the SunPass transponder data. Then they pulled Rivera and Garcia's cell phone records, and the cell phone pings and the transponder all went the same way. Weird. Also, Charlie, criminals know to turn off their cell phones. I don't know what Rivera and Garcia are doing. Y'all, turn off your... No, don't turn off your phone. Leave your phones. Leave your phones on. Leave them on. Makes life easier for everybody. Unless you're law nerds. You would never. However, everyone tracks your phone. The SunPass transponder activity is consistent with the cell phone travels. The transponder of interest in the case is that number. The SunPass account using the above transponder is a rental car company in North Miami, Florida. Law enforcement obtained the rental contract for a 2008 Toyota Prius on July 15th, 3 days before the homicide. The customer is listed as Luis Rivera. With a cell phone number listed, a second telephone number was also written on the rental contract. Garcia's phone with the word brother written next to the number. Rivera rented the car in his own name and listed his phone number and Garcia's phone number on the rental. Okay. The rental contract indicates the Prius was checked out at 6:15 p.m. on July 15th and rented to Rivera through July 21st, 3 days after the homicide. The Prius rented by Rivera on July 15th contained a GPS device installed by the owner to assist with theft or non-return. Theft or non-return is a huge issue. It's actually gotten a lot better, but it is an issue. But yeah, they have transpond. Rental cars have GPS. So do your phones. So does your SunPass. However, it makes it real easy for the prosecutors to be like, this is where the phones went. The GPS company records have the vehicle location on July 15th at 10:25 p.m. at the parking lot of 7501 East Treasure Bay North, Bay Village, Florida. This was the location of McBanawaz's residence at the time. Oh, so they were at her house. They rented the Prius and went to the go-between's house. Sometimes I will call her the middleman, the go-between, the connect, the link in the chain, whatever you want to say. But she's the one that they connected to Charlie with. So they took the rental to McBanawaz's house on July 18th at 12:26 a.m. The vehicle was located at North Monroe Street and East 6th Avenue, Tallahassee, Florida. On July 19th at 1:26 a.m., the vehicle was located at 1505 Northeast 135th Street, North Miami, Florida. This address is the residence of Jessica Rodriguez, who was a girlfriend of and has a child with Rivera. There's too many connections. We're just leaving some of it just alone. Cell data for McBanawa, Garcia, and Rivera is consistent with them being in the area of McBanawaz's residence during and around the time of the vehicle GPS showed its location to be in the parking lot of the condo. So they didn't just rely on the Prius, right? Because somebody can dump a car. They got all the cell phone records and they're like, the car GPS and the phone pings show that they're all in the same place at the same time. So weird. If they were doing this in 2025, they would probably also have social media data because social media will track who you are in close proximity to. So like Instagram would also be able to say if you are in close proximity to certain individuals. So a whole thing. Both Garcia and Rivera met with McBanawa the night before departing to Tallahassee to commit the murder. Analysis of Rivera's checking account revealed an ATM transaction took place in Broward County, Florida on July 18th at 6:46 p.m. as they were returning to Miami from Tallahassee. Security video from the drive-through ATM lane shows Rivera driving a Toyota Prius to the ATM at 6:45 p.m. and the Toyota Prius exits the ATM area at 6:47 p.m. A Florida license plate can be seen. The tag characters match those of the rental contract. They have him going to the bank. How much money was put in the bank? Was it cash? Cellular records show numerous contacts between Catherine and Charles and Sigfredo. On one occasion, telephone records show contact between Garcia and a cell telephone registered to Harvey Adelson, who is the husband of Donna, father of Charles and Wendi, on July 1st, 2014. At approximately 11:47 a.m., McBanawa's cell phone began to attempt to contact Garcia's phone. Over the next 5.5 hours, McBanawa attempted to contact Garcia 48 times. Even when I'm frustrated that Dr. B's not answering his phone, I don't know if I have ever called 48 times in a span of 5 hours. Normally, it's a couple times and then a text message being like, can you please answer your phone? And then I ping it and it goes boop, 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 boop. And he's like, shit. I should have answered my phone. Boop, 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 boop. Yeah, you should have. Especially if the internet's down. I will lose my mind. So, 48 times. Why is she pinging him 48 times? So weird. At 5:05 p.m., McBanoa made contact with Garcia and they had a conversation lasting 6 minutes and 22 seconds. Approximately 9 minutes later, at 5:20 p.m., Garcia's cell phone attempted to contact Harvey. The cell records indicate this call went to voicemail. No, Harvey has not been charged. So for all of you asking, Harvey has not been charged. Let's see. A different telephone number being used by Garcia prior to the murder had been in contact with McBanoa's number approximately 2,700 times. I'm going to say that again. Garcia and McBanoa's phones had been in contact 2,700 times between May 1st and July 19th, 2014. Look. 2,700 times. That's a lot of phone activity in not very many months. That's what? 2.5 months? A lot of phone activity. A whole lot of phone activity. On July 19th, Garcia's cell phone ceased activity. They're like, remember, that's the day after the homicide. Telephone number ending 8153 belonged to Rivera during the time leading up to the murder. The following contacts took place the morning of July 18th. The prosecution's going to lay all this out and just be like, look what we have here, folks. Why are they all in such fervent contact together? July 18th, 12 to 12:23. Rivera and Garcia's handsets communicate with cell sites in the area of Roadway Inn, North Monroe Street. 12:01, McBanoa contacts Garcia. 12:07, Charlie contacts McBanoa. 12:34 a.m., McBanoa contacts Charlie. 1:02 a.m., Charlie contacts Donna. 1:03 a.m., Charlie contacts McBanoa. Look, I'm just saying, Donna, I think, is almost the same age as my mother, who doesn't watch streams, but would kill me if I said that publicly. Y'all, shh. We don't talk about Bruno. We don't talk about Bruno. We don't talk about Bruno. But if my mother and I are talking at 1:03 a.m., somebody is probably in the hospital. Like, this is not the time of morning that we are having this conversation. There is nothing happening at 1:03 a.m. unless someone is ill or ill. Like, that's it. That is emergency hours at this point between adult me and my mother. So is that a little sus to me? Yeah, it is. Especially when you give the context of everything that's happening next. But at 1:02 a.m., Charlie just has a burning desire to talk to his mother about, I don't know, how to do his laundry or something. Because isn't Charlie in his 40s? Chat, how old is Charlie? 1:03 a.m., Charlie talks to McBanoa for 20 minutes. 8:09 a.m., Donna contacts Wendi. 8:50, what do you think that call is? Donna to Wendi. 35 seconds. Don't forget, Best Buy's coming today. Make sure you're home. That's just speculation on my part. 8:50 a.m., Dan drops his children off at their preschool. 9:02 a.m., Dan contacts Wendi. 9:12 a.m., Charlie contacts Wendi. 9:19 a.m., Wendi contacts Charlie. 18 minutes. 9:38 a.m., Charlie contacts Donna. 9:58 a.m., Charlie contacts McBanoa. 10:07 a.m., McBanoa contacts Charlie. 10:08 a.m., McBanoa contacts Charlie. 10:09 a.m., Charlie contacts McBanoa. 10:52 to 10:55, neighbor hears the gunshot, sees a small light-colored vehicle pulling out of Markel's driveway. 11 a.m., Subject on phone with Markel, attempts to call Markel back, call goes to voicemail. Subject in this case is Donna. Donna, who by all accounts hates this man. We're going to see emails about that. And at 11 a.m., 5 minutes outside of the window where the neighbor hears a gunshot, Donna's calling Dan Markel. You know what I want to know? When's the last time that Donna ever contacted Dan Markel? That's what I want to know in this trial. What do phone records say? When did Donna ever directly contact Markel? "11:01 a.m., subject texts Markel asking if he's okay." And some of you were saying that wasn't Donna. They say subject, if they mean someone else, they've mistyped it in this because subject in this is Donna. So subject in this is Donna. If they mean Wendi, it'll be cleared up at trial, but subject in this writing should be Donna because she's the one being arrested. Subject texts Markel asking if he's okay. 11:02 a.m., Markel's neighbor calls 911. 11:06 a.m., Donna contacts Charlie. 11:22, Charlie contacts Donna. They're on the phone for 7 minutes. 11:30, Charlie contacts McBanoa for 30 seconds. 11:31, Charlie contacts McBanoa for 5 minutes. Everybody in the chat who didn't know this case, how you doing? Wild, yeah? You guys are saying Charlie's 48, 49. Right, Charlie and I are around the same age. I know. It hurts my gut to say it too. He's slightly older than I am. Right. On the morning of July 18th, Garcia's telephone ceased activity just before 10 a.m. while in the area of the gym, with the last text message occurring at 9:58 a.m. The next event on Garcia's telephone was text message and or notification being received at 12:29 p.m. Immediately afterward, at 12:30, Garcia called McBanoa, which was the first contact initiated by Garcia after the homicide. This call occurred when Garcia's phone was in the area of Lake City, Florida, on or near I-75, approximately 1.5 hours after the shooting was reported. I mean, clearly Florida, because they said I-75, not the 75, but also it's a police report, Emily. Be cool. I love you, Chad. I love those of you being like, no, Emily's been a lawyer for 20 years. Obviously, she went to law school when she was 10. We're gonna roll with that lie. It's good. It's good. Yes. Approximately 2 hours after Garcia and Rivera arrived back in Miami, McBanoa departed her residence and went to Rivera's residence. My brain switched all the letters around. Emily, it's time for a vacation to the Riviera. Went to Rivera's residence while attempting to contact Garcia telephonically. While McBanoa, Garcia, and Rivera were together, McBanoa had telephonic contact with Charles Adelson. McBanoa traveled north to Adelson's residence, where she would remain until the following morning. McBanoa stated while at Charlie Adelson's residence, Charlie was armed and acting frantic. Charlie told his mother and father... Charlie told McBanoa his mother and father had just left his residence and left money that his mom had washed. Ma'am. Y'all, what year did Ozark come out? Cherry Balm asked, when did the boobs come into the equation? Later. After this. I know, all of you in the chat, I agree. I wish that my knees felt the way that they did when I was 20, but my attitude in the 40s. Like 40s brain, 20s knees. But then I would just be dangerous. For all of you like, wait, she literally washed the money? Yes. I'm guessing the gentle cycle, but probably didn't run it through the dryer because she didn't know how that would go. But yes, I don't know what the fuck Donna was thinking. I mean, writ large, all of this. Like, I don't know what the fuck Donna was thinking. All of this, Emily. All of this. I don't know what Donna's thinking. Like, you don't make this decision. But yes, wet money. She washed the money. What'd she think? There were going to be fingerprints on it? Do you think that's what money laundering means, that you get your fingerprints off of it? It doesn't have like your pheromones? What? Does Donna think that like police sniffing dogs are like, that money smells like Donna? Good Lord. Anyway, washed the money. Washed the money. Washed the money. Washed it. Which is why this is the Donna money launderer trial. I know that the internet is going to come up with all kinds of names for her. I've seen them. I like calling the cases Florida versus whoever the person is, or state versus person. Unless it's a federal case, then US versus person. But yeah, Donna the money launderer. Donna Wet Money Adelson. So, Charlie told his mother and father, Charlie told McBanoa his mother and father had just left his residence and left money that his mom had washed. McBanoa's testimony is going to be interesting. It seems that her give a fuck keeps changing, like over the amount of trials she's testified in, because her appellate rights are done. She's been sentenced to life. Florida life is just period, all. So I imagine McBanoa's give a fuck is decreasing. No, like actually washed. Yeah, with like the washing machine, with water. At Adelson's trial, McBanoa testified that the money she received was damp and moldy, consistent with being physically washed, and was stapled into $1,000 stacks. Ma'am hadn't watched a movie. Who said the Wet Bandits? Didn't the Wet Bandits crime at Christmas? Yes. She didn't even put it out to dry. Like, what are we doing? Stapled into $1,000 stacks. All of you like, who the fuck staples money? The same person who washes it with water. Emily, you're spicier about this trial. Look, man. A lot of people have already been convicted of this. This one hits different. So. McBanoa took a Xanax that was provided by Adelson and fell asleep. What do you want to bet? This is just me speculating. What do you want to bet he just improperly used his dental license to write that prescription? I'm just curious. It doesn't matter now. He's in custody for murder. But, you know, I'm just curious. Charlie, here, take a Xanax. It'll be fine. The next morning, 7/19/2014 at 9:44 a.m., McBanoa, left the residence and was told by Adelson that the money was in the trunk of her car. McBanoa attempted to contact Garcia. Communication records in Charlie Adelson's iCloud show Donna telling Charles she was, quote, outside your house at approximately 8:59 p.m. on July 18th, 2014. Cell records for Donna Adelson and Harvey Adelson show an arrival time of 1:25 a.m. in Orlando, Florida, leaving approximately an hour and a half time block consistent with her being at Charlie's house. Hey, Donna, what you doing at 1:25 in the morning after this murder? What are you going to say when you testify? That you're that upset? You just couldn't sleep? Your son hadn't prescribed you Xanax too? I've got questions. But since your attorneys have said you're going to testify, maybe they'll get answered. We'll see. Donna and Harvey traveled to Orlando for the evening, then on to Tallahassee the following morning. Prior to the homicide, McBanois was employed at a Miami area dental office. Investigation revealed that after the homicide occurred in July 2014, McBanois started receiving paychecks from the Adelson Institute for Aesthetics and Implant Dentistry, which were handwritten and signed by who, chat? Donna. Nani in the chat said, isn't money dry clean only? I mean, right? T said, house long to dry money. Apparently longer than they gave it. The paychecks started in September 2014 and were consistently in the amount of $407.58, which she received every 2 weeks. The memo section of each paycheck indicated it was for a period of 10 days, usually preceding the date of the check. The checks continued at least through April 2016. On at least 2 different occasions, McBanois received paychecks in advance of the time period indicated on the check and frequently received sequential checks. McBanois received a significant amount of cash after Markel's murder. In the month following the murder, McBanois deposited over $13,000 in cash. In the 6 weeks following the homicide, she deposited more cash than she did in the entire year leading up to the homicide. One of the things that was so telling in fraud prosecutions for me was the change in bank accounts. It was often starkly different. It was often starkly different. In the 6 weeks following the homicide, she deposited more cash than she did the entire year leading up to the homicide. These numerous deposits were conducted mostly through ATMs in increments of $300 to $2,000. From the homicide through November 2015, the total amount of cash that investigators identified deposited into her accounts is over $56,000. This amount is over and above the paychecks she had received. It's interesting that Wendi told law enforcement that Charlie said he could probably hire someone to commit a murder for $50,000. Isn't that a weird coincidence? The investigation revealed that McBanois did not work at the Adelson Institute. McBanois was in possession of and operating a 2001 Lexus LX 430 sedan automobile, which was registered to Harvey Adelson and previously used by Charlie Adelson. Harvey, did you know that your son was letting McBanois drive around in the Lexus? Why is it registered to you? Were these all registered through the business? I have questions. On January 23rd, 2016, the title for the car was transferred to McBanois and a new license plate was obtained in McBanois' name. Motor vehicle records indicate the vehicle was sold to McBanois for the price of $1,700. I imagine that was not the market value for the car, but maybe it was. Who knows? In addition, McBanois received cash and numerous gifts from Charlie Adelson since Markel's murder. A number of you in the chat said, the next person is the one I saw first. Why would you pay from the business accounts? Because payroll reduces your tax basis. The more you pay in payroll, the less you're paying in taxes. It's kind of a twofer. And it seems like the IRS hasn't come for Charlie. It's like, well, it's payroll. She was doing some kind of work. Not with the dental office, but taxes. You got to get that tax break. And the business is already closed and well, there's not much that they can do there because he probably, if he was paying her through payroll, probably paid the payroll taxes on it, even though she wasn't working there. And well, I don't know. I would have to look. Can you keep someone on payroll that's not actually working in your business if you are not doing it to defraud in other ways and you're paying the payroll taxes? I would need to think about that a little bit more. So I imagine that they just W-2'd her. If they were paying out of the business and it wasn't W-2, then maybe there's an argument that payroll taxes, I think taxes are probably the least of Charlie's concerns. But yeah, it's a little sketchy. Say Something said, what about Tati? In Tati's case, the business owners had not approved the payment. In this case, Charlie's the business owner, and it seems that he approved the payment. It doesn't mean it's not sketchy. It doesn't mean that there's not potential tax implications, but it's not fraud against the business because he seems to be the only owner of the business and he's the one doing it. Other issues, but it's not fraud against the business. I think there's probably other problems with that though, but I haven't really thought about it all that much. I'm sure it'll come up. I'm very curious if it's a W-2. Also, again, Charlie is in prison for life, period. The business is closed, and I don't know if there's any more money to be gotten out of this that's worth going after, but curious nonetheless. Let's see. In addition, McBanoel received cash and numerous gifts from Charlie Adelson since Markel's murder. Yes, apparently she was bragging in custody about receiving the boobs from Charlie. Does that count as part of the gifts? A review of their financial records indicate that Charlie Adelson and Donna Adelson had the financial means to finance this murder and provide ongoing compensation to McBanoel. And again, if continuing to provide her with finances is part of the ongoing conspiracy, the conspiracy is charged through 2016. So if they are paying her after the fact to keep her in good graces, that's part of the ongoing conspiracy. On April 19th, 2016, an undercover agent made contact with Donna Adelson in reference to Markel's murder. This you will hear referred to in trial as a bump operation. They had already been wiretapping, which is a whole process to go through, but they had already been wiretapping. The bump operation is kind of like shaking the hornet's nest to see if anybody talks after this, kind of poke the bear a little bit and see if they get chattier on the wire, which also takes quite a lot of work to even get approved. But on April 19th, 2016, an undercover agent made contact with Donna Adelson in reference to Markel's murder. The undercover agent provided a press release of Markel's murder, asked for $5,000, and provided a phone number at which he could be contacted. As a result of this contact, conversations were intercepted. So the bump worked, and it was just like, and they all got chatty. Call number 1380, Donna Adelson called a Charlie Adelson asking him to meet her and about some paperwork that was hand-delivered to her outside her condominium. The Icon on South Beach was intercepted. During this conversation, when Charlie inquired whether it involved him or others, Donna responded in a whisper, well, probably both of us. When Charlie asked her to repeat herself, she said, probably the two of us. And you probably have a general idea what I'm talking about. When Charles inquired further, Donna said, don't be a dumbass, Charlie. No, I'm sorry, that's not what it says. My brain just interceded. Donna said this was not something she wants to discuss over the phone. Mom, what? We're not talking about this on the phone. You know what I'm talking about. He's like, that was 2 years ago. Just my speculation. Call number 1382. Donna and Charles discussed meeting and whether or not Charles needed to bring cash. Mom, do I need to bring money to this meeting? Wet money, dry money? What kind of money are we doing? Charles inquired whether or not a threat was involved and whether the police should be contacted. Mom, do I need to call the police? Charlie, no, you don't call the police. This is like people who get robbed in the middle of narcotic transactions and they call the police and are like, look, I was just trying to buy insert name of illicit narcotic and they stole my money and didn't give me the drugs. And the police are like, let me get this straight. So you called me because you are involved in an illegal transaction, and while taking part in that illegal transaction, that person robbed you. What would you like me to? I'm sorry, do you want us to go get back the money or do you want us to go get the drugs and what? No. You what? Huh? Do we need to call the police? Donna responded at this time she did not believe that was a good idea. No, Charlie, it's not. We shouldn't call the police. What are you going to call the police and tell them? Somebody's asking me for money because they know I was involved in a murder. And if I don't give them money, they're going to tell everybody. Is that what you're going to call the police and say? Okay. Call number 1386. These are all the wiretap calls, which means they're recorded. I can't wait to hear what she has to say about these calls when she testifies. Call number 1386. Oh, there's my chat. Yay, chat. Call number 1386. Charlie Adelson called and immediately told his mother, Donna Adelson, don't talk about things in the apartment or any place. Don't speak. He then asked if the person was black, white, or Hispanic, to which Donna said he was white. Charles said it sounds like something that needs the police. Donna said she may have to, but wants to talk to him first. When Charles asks what the letter asked for, Donna said, this TV is probably about $5. Charlie asked if they asked for $5,000. And Donna responded affirmatively. Donna also said they mentioned an ex-girlfriend. Donna's trying to be on the low, and Charlie's like, huh? This TV is probably about $5. By the way, the TV reference, 10 out of 10, that they were talking about getting Wendi a new TV, that they were talking about fixing Wendy's TV when Best Buy went there. The TV references are strong. This TV is probably about $5. And he's like, you mean $5,000? Yeah, Charlie. We're not actually talking about TVs, Charlie. They're not actually talking about TVs. They need to be on FaceTime where she can be like, the TV. But no. Donna also said they mentioned an ex-girlfriend. Charlie, they want $5,000? They're talking about your ex? The one who holding the thing? The thing? With the TV? With the broken TV? Call 1392. So Charlie goes and calls his ex. Charlie called Catherine McBanawa after trying to reach her by phone unsuccessfully about an hour before. Charles explained the situation to McBanawa as he understood it from his mother. Something regarding her son, something regarding his ex-girlfriend, and the person asking for money. Charles tells McBanawa that he is going to see his mom the next day to discuss it with her. There is some discussion of whether McBanawa is the girlfriend referenced by the agent. Charles said he thought his mother said the agent, and they're not saying agent, they're saying person, said the agent mentioned McBanawa's name, but he's not sure and will follow up with her if the situation does involve her. She agrees to meet Charlie in person the next day, April 20th, 2016, around 4 p.m. Remember, the conspiracy goes through 2016. This is why. Charlie never contacted any other females to discuss the contact between his mother and the undercover agent. So Charlie wasn't hitting up others and like, hey, some guy's asking about my ex. No, just McBanawa. The morning of April 20th, Charles told his mother he would meet her at home at 12:35 p.m. After Charlie arrived at the Icon where his mother and father reside, he and Donna walked outside to a remote table behind the building and sat close together while conversing. None of their conversation was successfully captured. Well, right. It's exactly what they're trying to do. I would suspect. After meeting with Donna in person, he called McBanawa and traveled to her in Sunny Isle at the real estate office where she worked. When Charles arrived at the strip mall where McBanawa worked, they talked briefly outside, then went into a restaurant, Dolce Vita, near the real estate office. So at this point, they also have a tail, right? The reason they know this is because they are tailing Charlie. This is an incredibly successful bump operation. They nudged just a little bit. Look at how much activity unfurled by asking a few questions. That's why they did this. It was a little nudge of like, what's going on? So then they went to lunch. Their conversation was captured while they sat in the restaurant from the tail. The following statements Charles made directly to McBanois were previously only audible with use of proprietary software. Through the use of an expert, the audio conversation between McBanois and Charles was clarified. The following are portions of that conversation, which we're going to hear, I'm sure, at trial. 1. If they had any evidence, we would have already gone to the airport. I thought Donna just wanted a vacation. If they had any evidence, we would have already gone to the airport. The problem is, even if they bugged this, even if they bugged your home phone, but even if they had bugged your phone, okay? But even if they bugged your phone, okay, you're still not talking about any of this. So my point is, how do you get people to talk? You throw in a smoke grenade, and then you get all the roaches to run out. So you knew it was a bump operation? Because you are talking. That's exactly what the fuck you're doing. You're talking. He said, there's smoke in the house. There's smoke in the house, and everyone's running, and everyone's talking, and you throw a smoke grenade. What do you think? He's like, well, this is what you do to get people to talk, and yet you're talking. He thinks the restaurant was pretty hard for them to pick up the conversation. Easier now, harder then. They may have approached my mom because my dad may be someone who is carrying a gun. You think they approached your mom because they're afraid of your father because he's packing? They approached your mom because she's a talker and they think she's the tip of the spear. And she did exactly what they thought she would do. You never know if someone's, you don't want it to turn into a fucking shootout, And I can tell you, a lot of times I carry on me. I mean, someone comes up to me, and then it sounds like KM is McBanois. You carrying on you right now? I mean, I'm going to start carrying one on my back, like, a holster that fits in your shirt. If someone comes up to me, they better be ready to shoot because I'm going to shoot them. Someone comes up to me asking for money right now. Yeah. And guess what? When the fucking police show up and there's a doctor, there's an oral surgeon standing there with a dead gang member in the fucking driveway, they're not going to come down too hard on me, and I'm not going to talk anyway. I don't know much. I don't trust them. First of all, are you an oral surgeon? I have questions. Second of all, my family and I just watched Easy A. The Who Are They Gonna Believe is so incredibly on point for everything we've seen from Charlie's personality. But also, we know exactly what he thinks. Also, I don't think you're going to outdraw a gang member. It depends on the gang member. Some are terrible shoots like stormtroopers, but it really depends on the gang member. I don't know if you're going to outdraw a gang member. Their spidey senses are tuned a little tighter than yours are, Charlie. So I know you want to talk like you think you're a badass, but who do you think they're going to believe? Who do you think they're going to believe? I bet your jury loved that. I was wrong window, Emily. I really, really want to know if he's an oral surgeon. Hold on. I'm super curious. I'm very curious. Oh, the news just calls him a dentist. Oh, he must be so deeply offended. Hold on. A South Florida dentist was convicted. They don't put his specialty in here. Oh, don't you know who he is? He is an oral surgeon, people. I don't even know if that's true, though. The news just calls him a dentist over and over and over. I'll find it. And then I will find it because the attitude is giving, I'm not just a dentist. But I don't know if you're actually an oral surgeon. Because a periodontist would call themselves a periodontist. But give me 1 second. I'm just super curious. Emily, do we need to get Dr. B in here? Yeah, a periodontist. Hold on. We have a dental side quest real quick. Where are we? We've got a dental emergency. We've got a dental emergency. Don't worry, we'll get into what a periodontist is. Don't worry, chat. We'll get there. I doubt my husband's gonna answer his phone though, so we're gonna have to text him 48 times. But also, periodontists are periodontists. They're not oral surgeons. It's a whole different. We're going to come back to this topic about whether or not a periodontist is an oral surgeon. We'll get there. Don't worry. I think he's elevating himself. Periodontist, though, even if he was placing implants, still not an oral surgeon, because oral surgeons have to have an MD component, not just a DDS component. However, we'll come back to that. Emily, you're getting stuck in the details. Well, yeah, because he's like, I'm an oral surgeon. Sir, sit down. All right. Continuing on this wiretapped conversation where Charlie Adelson thinks that he's an oral surgeon and that he's going to outdraw a gang member and that the police are just going to believe him because of his profession while he's talking away, while has a tail, while has a wiretap after a bump operation because they're on to him. I'm not going to talk anyway. I don't know much. I don't trust them. You're sure chatty, Charlie. Katie, this is not like some chick showing off tattoos to your man. What the fuck is this analogy? This is happening and it's serious because these people are going to come back. They didn't go through the trouble of seeking my mom out to hand her that and go away. That the press release about the death. So I got two options. They're not going away. May wish they'd go away and never come back, but they ain't going away. The trouble they went through. No, it's very simple. Like, if you're going to charge me, charge me. They did. What I'm saying is that this person is not going away. They came very equipped with details. Where did the details come from? I don't know. The details. Oh, the details in the details. Don't you wish you knew where the details were? Thank you. All of you are saying his LinkedIn says periodonist. Mm-hmm. To them, said the guy's name was 2-0. I don't even know who the fuck it is. Is there just 2-0? KM Supply's name. Tuto. Tuto's incarcerated now. And I know that you've been helping out Katie and helping your family and helping out Katie and her family. Now Tuto's family needs your help. My mom was like, I don't know what you're talking about. And he goes, well, maybe this will refresh your memory. We're going to see the whole bump operation because it's filmed. We'll see it in trial. Well, maybe this will refresh your memory. He handed it to her. KM starts talking and she said, respect, spoke like polite. She goes, polite and well-spoken. I said, did he act thug or did he have talk with a thick Spanish accent or anything? She said, no. I said, was he white or Hispanic? She said he was white, but he could have been Hispanic. And then KM's talking. Yeah, could have mistakes. I mean, everybody in Miami is Hispanic. So it's like, you can't tell. So Katie, they'll be back. These people know about whatever it is, knows information. These people know about the thing. They know about the thing. They know about the thing. They know that They know the thing. Don't tell them, but they know the thing. No wonder Charlie's jury came back in like 3 hours. Let me ask a question. When everybody was there the next day, did any of you take any money? It's not like you're driving around in a Bentley, cruising around in a mega yacht, you know. No, but she put an entire annual income in her bank account. So, you don't need a mega yacht to have money disproportionate to what was the normal and consistent. When they pull your bank accounts, they look in the past as well. Like, Charlie, it's not like you're driving around in a Bentley or a mega yacht. You know, he must at some point, because otherwise he'd have no idea that I had anything to do with. It could. I wish it was a cop playing games. Ding, 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 ding. Why didn't they know it was me? I wonder if Donna's attorneys are going to argue this and be like, it was just all Charlie. It'll be interesting to see if the attorneys throw Charlie under the bus. Like, no, Charlie asked his mom for money, and so she gave him money. No, it's just all Charlie. I just wonder how much her attorneys are going to throw Charlie under the bus. He says it could. I wish it was a cop playing games. Why didn't they know it was me? If it was a cop playing games or an investigator playing games and they didn't mention me, they did mention your son's girlfriend, Katie, not mention me at all and my family. And I think if they thought I had something to do with it, they would find me or they'd talk to me. You know what I'm saying? Like, go to the person who's involved, not fucking people who aren't involved. Interesting. Very, very interesting. And I wonder if her lawyers are going to argue that, see, Charlie's saying Donna's not involved. And if I'm not involved, but if like they knew, I inserted that like, but if they knew your relationship with me, not my family, like I dated you, not my mom. There's a lot to unpack there. We don't have time for therapy today, Charlie. We're still stuck on the fact that you're saying you're an oral surgeon when you're a periodontist. But periodontists have egos of their own. I don't understand. We're not unpacking all of this today. Like, I dated you, not my mom. I think he's saying, like, my mom wasn't dating you, but therapy. That's the direct connection, is who was her boyfriend, the 71-year-old guy, Dr. Adelson, or the 37-year-old Dr. Adelson. Is his dad a dentist too? Harvey also a dentist? It sounds like it. That doesn't surprise me. Yeah, 37. Let's go talk to him, Dr. Adelson. That's who they'd talk to, not waste your time with mom. Depends on what they think mom's up to, Charlie. Because mom got this whole hornet nest in a tizzy, didn't she? Because if they didn't talk to mom, you're not having this conversation. They needed to talk to someone who knew what the fuck went down. And so wouldn't it make sense that your connection to my family is me? Or they know more than you think they know. I know that you know that I know that you know that you know that I know. Thank you. Chad is like, yeah, it was the family practice. And they practiced together. Your connection to my family is not my mom. Like, yeah, you work for the office now because the checks are from there. Well, the place of work you want to go have lunch with her at isn't your dental office, is it? And that's just because you come in and work on the weekends, which I trust that you're doing, because I'm never there when I see you. You tell me you do it and the place looks clean, so I get your checks. You clean up, whatever, but that's neither here nor there. This person knows information, and even if they are cops, the information said your name. And they also know that they're claiming that somebody who had something to do with it is incarcerated. I don't know anybody in jail. Well, that's clear. McBanawa says him. It goes on. I told you this was 24 pages. I said get a snack. Everyone who's regretting not getting a snack, I apologize. I warned you that snackies were needed. I said snacks are necessary. So, continuing on, this is what I want you to do. I want you to call up this person and say that I got a call from some friends of mine. Oh, you want McBanawa to walk the dog? What's up, Corey, Charlie, whoever? This is what I want you to do. I want you to call up this person and say, I got a call from some friends of mine who say that you reached out to them and you mentioned my name. And remember, protect your name recently. I'm interested to hear that play out. So what you're going to say is, I got a call from some friends of mine who said that you had reached out and that you had mentioned my name. The people want to go to the police because they had nothing to do with what you're talking about, okay? And frankly, I don't know what you're talking about. These people had nothing to do with what you're talking about. I mean, I don't know what you're talking about, but they definitely had nothing to do with it. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate. But do not contact these people again, or they are going to call the police. So he wants Catherine to go back to the undercover and be like, I'm going to give you something as charity, but leave these people out of it. Sure, buddy. Sure. Me trying to change windows and doing it badly. Sure, buddy. I don't know what you're talking about. They had nothing to do with whatever you're talking about, even though I don't know what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar to who's incarcerated. So I'm going to give you something as charity money to help the less fortunate, but do not contact these people again, or they are going to the police. The police are like, lol. And let them know you had to do everything in the world to prevent these people from going to the police because they don't know anything and I don't know anything. The undercover officer is going to be like, oh no, not the police. Don't do that. And that the name sounds a little familiar, and I'm going to help you with some charity, and don't ever contact me, my friends, or my family again, or we will call the police. Oh no. I mean, Katie, I'll go to the moon and back for you. That's without even saying, I don't need to say that. And then it sounds like she cuts in and says, but that's what it's like. You know what I'm saying? No. Cam says, help me out. Help me out. Like, you know it. I don't even have to. I don't have to sit here and tell you what I would do. I could show you what I could do. You ask, you know what I'm saying? No. Like, you know how I'm like. I look for things to do. You don't ask me for shit. I'm the one that's like, hey, Noah's birthday's coming up. I got you. I'm the one who's like, anything I can, you don't ask. I'm the one who's like, hey, I'll sell the Lexus for a good price. I know you are having car problems. You know what I'm saying? No, I don't know I don't know what you're saying. Like, I'm the only one who I don't have to tell you, I show you. There's a difference. Okay. I think this is Charlie continuing. I know my head was, when I was leaving the house, literally had the bag out and I had it with my car keys. I know, well, if you want, you guys can swing by my house later. So what are we doing? And then it sounds like KM talking. I want you to take it back, write the number down. I'm going to give you cash and I want you to 712 what? 6570. I don't, we'll hear that in trial, I'm sure. After the in-person meeting with McManawah. So now we're out of the in-person meeting. So that is what they were able to recover from the recording at lunch. After they bumped Donna, Charlie goes to Catherine McManawah and is like, tell them we don't know shit, you don't know shit, but whatever we do know, we don't know, and then give them money. And then tell them everyone's going to go to the police. Okay. After the in-person meeting with McManawah, Charles called Donna back to report about his meeting and said he is handling everything. Donna then calls Charles back, sounding very concerned because there's a wiretap. On April 21st, 2016, calls were intercepted between McManawah and Charles, and they attempt to disguise their conversation using real estate references such as security, property posted incorrectly, wrong tenants for rental property. Charles and his dad, Harvey, met for dinner later that evening. McManawah and Harvey, are you still in the U.S.? Because, it seems like the prosecution's just picking people off one by one here. McManawah and Garcia were intercepted having numerous arguments over the phone. The morning of April 21st, 2016, it appeared McManawah was trying to convince Garcia to figure out who the phone number belonged to and place the call himself. In a heated exchange, Garcia said, "I'm not making that fucking phone call." He later said, "I'm going to take care of this fucking problem." That was call 825. On Monday, April 25th, 2016, a letter was sent to Harvey and Donna. This letter was sent via USPS by investigators for the purpose of follow-up from the undercover's initial conversation. Just a little more bump. They talked so much. It was just like, let's just chat. Let's see if they say anything else. They were so chatty. Let's just see. Calls intercepted indicate Donna shared the information with Charles, who in turn forwarded it to McManawah. McManawah again asked Garcia to either determine who the phone number belonged to or call the phone number. McManawah reported to Charles that the phone was either out of service or not a good number. It appeared Garcia lied to McManawah about making the call or had not called the correct number. The agent's phone was not called and was working properly after conducting tests to verify. Right. Because that's a burner phone from the agent. And the agent's like, no, my burner phone's working just fucking fine. Right. And Garcia's like, leave me the fuck out of this. Later that same day, Charles called McManawah to ask if she was on her way. It appeared Charles and McManawah had been communicating through a different source to schedule a meeting. Yeah, because when you hear on the wire, oh, are we meeting? Then everybody listening to the wire is like, well, shit, how are they talking now? It appeared Charles and McManawah had been communicating through a different source to schedule a meeting. Later review of iCloud messages from Charles's records indicate he and McManawah would communicate via WhatsApp, all backed up to your iCloud, a phone application that allows for secure communication not retrieved in a cellular record. But in your backups, right? If you're backing up your WhatsApp conversation to your iCloud, it's going to show up. Charles directed her to Harvey and Donna's building to meet with them. To meet with your mom that doesn't know anything about any of this? Sure, Jan. Charles told McManawah he was talking to his parents about everything. She's telling them everything. A lot of you in the chat said, should have used Signal. Was Signal around in 2016? I don't know. Charles directed her to Harvey and Donna's building to meet with them. Charles told McManawah that he was talking to his parents about everything. Charles continued to try to convince her to meet at Donna and Harvey's building, but eventually agreed to meet with her at another location. McManawah called Charles back, who advised her they were meeting at a marina near Monty's. April 26, 2016, Charles called Donna and they discussed the conversation that occurred the night prior. Donna said she felt better after their conversation. Donna asked Charles to let her know once things had been taken care of. Call 1948. He further stated that, quote, if you don't know who the person is, it's a much bigger problem. Charles said, if you know who it is, it's very, very easy. It's very, very easy. Charles told Donna to stop getting worked up about things. Oh my God, Mom, chill. Charles assured Donna there was nothing she needed to worry about and that it was being looked into. Well, Charlie, it seems that Donna was correct. On May 4th, 2016, at approximately 2:09 a.m., a text message was sent to Donna's cell phone from the undercover agent. At 2:09 a.m.? The undercover is like, oh, she's anxious. We know she's up. Later in the day, Charles asked Donna if she was okay, and Donna advised she would talk to Charles about it on Sunday. Charles wanted to talk to Donna before Sunday, and they agreed to Charles coming by around 11:30 a.m. the following day, May 5th, 2016. While driving to meet with Donna, Charles called McBanawa, advising there was a new problem and that he needed to meet with her later that day. Look at how fortuitous this bump application was. All. On May 5th, 2016, Charles arrived at the Icon and they agreed to meet at the pool area to discuss the text message. This time, Harvey is present with Charles and Donna as they huddled at a corner area for privacy. There was no oral interception captured due to the location they had the conversation. They went to like the far back corner and the tail didn't reach. So they had a conversation. No one knows what they know, but law enforcement doesn't know the nature of that conversation. After the meeting, Charles left the Icon and called McBanawa, call number 2016, asking her how someone would get his mother's number. McBanawa told Charles it's possible to locate the phone number online. Charles used specific phrases sent via the text message. So Charles knew what was in the text because he told McBanawa. Charles called Donna and they discussed paying the $5,000. Charles advised the sooner they pay the money, the better. They discussed being nice but firm with the money when the money is paid so the person knows it is only a one-time payment. I imagine we're going to see Donna argue that they were being extorted. But like, if you didn't do anything, just go to the police and be like, somebody's trying to extort me over some shit that I had nothing to do with. The fact that you didn't go to law enforcement actually, I think, is going to be more telling for a jury, but we'll see how it plays out at trial once a jury's selected. On Friday, May 6th at 5:03 p.m., Donna successfully contacted the agent by calling his phone number. The total duration of the call was 8 minutes, 48 seconds. The call was recorded by who? Chat, by who? Who? Who recorded it?
The FBI! The FBI!
The call was recorded by the FBI, so they're definitely going to play that in trial. In summary, Donna made the excuse her grandchildren had possession of her phone, so she did not know the agent called. Donna went over the previous contacts between herself and the agent. She said she took him seriously and she was stressed out. She claimed she asked friends what she should do. Are those friends lawyers? If you're that stressed out, go to the police. Unless you're worried that the police are going to be like, well, why would somebody be saying that to you? She denied knowing anything referenced by the agent concerning help provided to her by the agent's friend Rivera. She then brought up the reward offered and suggested he seek that out instead. Reward offered for information regarding the murder of Dan Markel is what she's referencing. Thank you, chat. All of you were just like, all of you, the FBI, the FBI, the FBI. Thank you. Susan said, I will always try to be firm in my conversation with extortionists. Look, if you are being extorted, it is against the law. And it's pretty easy to prove when people just go to the police. Donna didn't want to do that. Gee, I wonder why. She then brought up the reward offered and suggested he seek that out instead. The agent reminded her all he asked for was $5,000. Donna claims she had nothing to do with the death of her ex-son-in-law and that she was left out of the loop. The loop of what, Donna? What loop? Hold on. I'm texting Dr. B real quick. She was out of the loop. The agent reminded her the problem was not going away, and she did know McBanawa and what was done for her. Donna continued to deny knowledge and ended the conversation by saying she would call the agent back. Sort of like when she was in Tallahassee and she's like, I'll get back to you. And then she pieced out to, Miami and never called them again. Call number 3290, May 7th, 2016 at 5:07 p.m. Charles told McBanawa about a new CD he wanted her to listen to. 2016. Indicating that he had a recording of the call between Donna and the agent. Charlie used the reference potbelly pigs, and they put in paren police because they're like, sometimes people refer to the police as pigs. They're referencing the cops. To which McBanawa responded, that's not good. On May 25th, 2016, Sigfredo Garcia was arrested for his involvement in this case. On May 26, 2016, electronic surveillance suggested that Charlie Adelson and Catherine McBanawa were in close proximity to each other and may have met in the overnight early morning hours. On June 28th, Luis Rivera was arrested for his involvement in this case. On September 30th, 2016, a proffer was conducted with Luis Rivera in the presence of his attorney. The proffer was not recorded. Rivera was sworn prior to any testimony. So a proffer is, well, tell us what you know, and maybe we'll offer you a deal. And if you tell us what you know, and we don't offer you a deal, we can't use any of this against you. So a proffer is, let's see how fortuitous your snitching is, and then we will see if we can help you out. Rivera stated that he had known Sigfredo Garcia since childhood. Garcia told Rivera about a high-dollar robbery he wanted to do with Rivera in Tallahassee. A travel to Tallahassee was in June 2014. Once they departed for Tallahassee in June 2014 was when Rivera learned Garcia wanted him to commit a murder, not a robbery. Garcia's like, the fuck, bro? Robbery carries a way different sentence than murder. While en route to Tallahassee, Garcia provided Rivera... Oh, I skipped a sentence. Garcia promised Rivera $30,000 to commit the murder. See, everybody takes a cut. There's lots of middlemen. We went from $50,000 probably to $40,000 to $20,000. While en route to Tallahassee, Garcia provided Rivera with more details explaining a woman with 2 kids wanted her ex-husband murdered so she could have full custody of the children in Miami. I don't think he's referring to Donna. What do you think, chat? Do you think he's talking about Donna? I don't think he's talking about Donna. Garcia told Rivera the offer was presented to him by Catherine McBanawa and the total payment for the murder would be $100,000. Rivera suggested robbing the woman of the $100,000 instead of committing the murder. Look, Rivera's like straight up. These people seem like they're pretty, like they're not exactly savvy. So let's just take the money. I mean, what the fuck are they going to do? Call the cops? How's that call going to go? I'll tell you how that call's. Let's talk about how that call's going to go. Excuse me, officer. We asked these guys if they would murder ex-husband for $100,000. They took the money. They did not commit the murder. I've been robbed. Help. What would you like law enforcement to do? They'd be like, wonderful. Why don't you just turn around, put your hands behind your back? We're going to go ahead and we're going to just lock that up. We're going to sit down and have a little chitty chat about solicitation of murder and conspiracy to commit murder and attempted solicitation of murder. Because even though they didn't follow through with the murder, you solicited someone for murder. So, and then they took the $100,000 from you and didn't commit the murder. What, you want to sue them for breach of contract and have the police arrest them for robbing you? Okay. Really? Back to this. Rivera's just like, can we just rob them, please? It would be easier if we just robbed them. Just let's take the 100,000. The robbery's gonna go way better. We're not gonna go to jail for murder. Let's just take the money and run. A whole song about it. Emily, you're assuming that they're fans of the Eagles. Why not? Isn't everyone? The two traveled with a long barrel .38 Taurus revolver and a short black barrel .38 Smith & Wesson revolver. The two around the victim's residence, that's an awkward sentencing, and followed the victim's vehicle. Rivera recalled Garcia having a colored printed photo of the victim with words printed on it. Well, yeah, you don't want to get the wrong person. Oh, Steve Miller, thank you. Take the money and run. Appreciate it, chat. Steve Miller's 10 out of 10. So you can't get the wrong person. So a picture of the victim makes sense in this circumstance. Rivera could not recall what was printed. This is 2 years later. That doesn't surprise me. They would eventually park the car at Winthrop Park and wait for the victim to leave. Rivera would later show investigators where they parked and the routes that they took to the victim's residence. He's like, I'll tell you everything. I'll tell you all of it. I'll show you where we drove. I'll show you what we did. What do you need to know? Rivera indicated Garcia told him McBanawa approached Garcia with the offer of $100,000 to be divided amongst the three. 40 for Garcia, 35 for Rivera, and the remainder for McBanawa. She's like, I'm taking my cut of the deal that I'm negotiating. Garcia later offered $2,000 more to Rivera. After losing the victim and failing to complete the murder in June, the two decided to return to Miami. Approximately a month later, the two returned to Tallahassee to commit the murder. Rivera rented the Prius in his name. They arrived in Tallahassee in the early morning of July 17th, 2014. The same morning, July 17th, they drove to the victim's neighborhood. While driving around, Garcia involuntarily discharged the revolver through the floorboard of the Prius. Rivera noticed the car started losing power, and they learned Garcia shot a hole through the gas line. Oh, so it was not a full electric Prius. They were able to repair the vehicle and continue traveling. Was it duct tape? I bet it was duct tape. They're just like, it'll be fine. A search warrant was issued in October 2016 for the Prius. The fuel line underneath the passenger side of the vehicle was spliced together, and the corresponding hole was located in the floorboard, consistent with the information provided by Rivera. When I tell you that the police like to corroborate the stories that they are told by informants and those who are looking for a deal, this is exactly what I mean. Actually, we actually shot through the floorboard and we fixed it up, and the police went and found the car and were like, sure as shit, there's a hole in the floorboard. That's the kind of corroboration. That's the type of corroboration we expect, right? This is the corroboration. They went and found the Prius, and the Prius had a hole in the floorboard consistent with the information. They are doing this investigation 2 years after the murder. The following morning, July 18th, Rivera and Garcia traveled back to the area of the victim's residence when they observed the victim leaving the neighborhood. They followed the victim around as he dropped off his kids. Look, this case is horrible, though I am making fun of the dumb fuckery that is happening here. This case is horrible for the Markel family, for the kids, but the fact that they waited for him to drop off his kids, if there is any small silver lining in this, which is hard to say in a murder case, it's that the kids did not see this. It's that they did not kill him while he was in the car with his kids. It's horrible, but not all cases go down where the kids are spared from what they would have otherwise seen. At at a bare minimum, at least the kids got dropped off, but it's horrible for the kids because the kids were in preschool when this happened 11 years ago, and they're with their mom, and they have watched 3 people get tried for the murder of their father, then their uncle, and now their grandmother. It's fucking horrible. Absolutely horrible. So, in all of this, though the ridiculousness is ridiculous, the core of this case is incredibly sad. And I imagine that the family members that the kids are with are still living with tremendous stress because the people arrested in this case have been picked off one by one by one. They didn't go through and swoop everybody up. And I imagine that there's a level of stress of waiting for the other shoe to drop that will always be there. Because Charlie thought, well, if they had evidence, I'd be on a plane. Nope. And it seems Donna thought the same thing. And she was just ready to put her foot onto that plane. And they were like, yoink. So I imagine there's a level of stress. And the more people sit in custody for the rest of their lives, I wonder if the more they're like, you know what, if I'm sitting here, so the fuck are you? And each time they testify, I wonder if it's going to just provide a little bit more detail. We'll see. Because right now the kids are with Wendi. I don't know if they're ever going to charge Harvey. But we'll see if they were just keeping Wendi out of custody to testify in all of these trials and then swoop her up at the end. I don't know. But I feel horrible for all the kids that are caught in this because it's more than just the Adelson kids. Because McBanoa has kids. I think Rivera and Garcia both have kids. It's more than just the Adelson kids that are caught in all of this. So they were following him. The hitmen are following around the victim when he drops off the kids and goes to the gym. He gets home. They pull up in his driveway. They pull behind his car. As he parked in the garage, Garcia exited the Prius, approached the driver's side door of the car, shot the victim twice in the head, got back in the Prius, left Tallahassee, traveled north on Thomasville Road to I-10 to I-75. It's very hard for me to not say they took the 10 to the 75, confirming the information previously disclosed through electronic data. So now the police have multiple points of corroboration for what they are being told in this proffer. While driving back to South Florida, Garcia called McBanoa approximately an hour into the drive. Garcia told McBanoa it's done. Rivera explained he could hear McBanoa's voice as Garcia held the phone up to his ear. During the drive, Garcia asked Rivera to pull over near a bridge and waterway so Garcia could dispose of the firearm. Numerous attempts to locate this bridge and waterway were unsuccessful. Upon returning to South Florida, Rivera and Garcia withdrew cash from the ATM in Pembroke Pines, and they were observed on an ATM security camera. They then drove to Rivera's residence. The following morning, Rivera received a call from McBanoa, and this is all the proffer. She told him if he wanted the money, he needed to tell her where to meet because she could not get a hold of Garcia. Rivera knew Garcia was at Stephanie Carbona's residence, so he called a friend, Anthony Ortiz, to go pick him up. While waiting to return home, Rivera received a call from his child's mother, Jessica, who he lived with. Jessica told Rivera and Garcia that McBanoa was at their residence with a package for them. Rivera returned home and observed McBanoa's white SUV in the driveway. As he entered the residence, he received a package from McBanoa and Garcia. Rivera did not want Jessica to know what was in the package. Rivera then left the residence with Garcia. Rivera described the package as a stack of cash, $100 bills, stapled together. In July 2018, contact was made with June Umachita, who was a girlfriend of Charlie Adelson at the time of the undercover operation. So Charlie's new girlfriend, when the bump operation was happening, was interviewed. Of relevance in her interview was her recollection of Charlie Adelson having stapled money in a safe in his residence. What the fuck? June stated she followed the case in the news, and when she heard about stapled money, she found it odd because she remembers Charles keeping his money that way. Who does that? And can you imagine being this girlfriend and being like, oh shit, that's weird. That's suspicious. That's odd. Yeah, what? You can't use a rubber band because the money's wet and it'll rip? You don't have a little binder clip? Not a paper clip? Stapled? I mean, you go to all the trouble to wash the money and then you keep it in the oddest way possible that is so specific it ties it back to you. You don't have an envelope? Seriously? The dental office has no paper supplies. Staples are all we got. Because that is so strange and specific. So strange and specific, in fact, that the girlfriend's like, huh, that's strange. Who does that other than my boyfriend? Also, why is he showing his girlfriend the money in his safe? Oh, wait, we know why, don't we? She thought it was odd because Charlie keeps money in his safe that way. She also testified that Charlie was acting angry, agitated, and nervous around the time of the undercover operation and the McBanawa arrest. Adelson advised June that he gave McBanawa a car and financed a portion of her breast augmentation. There it is. There's the boobs. I mean, she's my ex. I gave her a car and boobs. Girlfriend June observed Donna Adelson to be stressed out during this time frame, and Donna also made a statement to June that she felt Dan Markel was haunting her from the grave. That must be hard for you, Donna. Watch my sympathy face. Wait, I just can't make it work. I'm law nerds. You are 10 out of 10. I am so sorry that Google is blocking murder boobs. Amanda in the chat said tough titties. I see all of your comments. They're grabbed by Google faster than I can undo them. Apparently Google hates boobs. Google, why do you hate boobs? I appreciate y'all. I see the comments. All of you are very funny. Who said bumps and boobs? Laura said bumps and boobs. Yep. My lumps, my lovely lady lumps. Check it out. But apparently he only financed part of her breast augmentation. But McBanawa was telling everybody in custody that he paid for all of her boobs. I don't know. They're not getting repossessed. It doesn't really matter at this point. Donna told June, who I'm sure we'll see testify at trial, that she felt Dan Markel was haunting her from the grave. Interesting statement, Donna. In July 2021, contact was made with Ryan Fitzpatrick. During the interview with Fitzpatrick, it was learned that the two had a falling out in recent years over financial disagreements. The two who? Him and Charlie? Information's missing in that sentence, but I'm assuming Charlie. He said Charles's entire demeanor changed when McBanawa was arrested. Weird. Adelson started putting up security cameras and was constantly paranoid of arrest. Strange. During a conversation with Fitzpatrick, Adelson said, quote, "You can get away with murder if you keep your mouth shut." Weird thing to say, Charlie. Also, do you know what keeping your mouth shut means? Because that's sure the fuck not what you're doing. Fitzpatrick also stated he knows Charles staples his money together because he had received money from him in that matter. Charlie, why are you throwing so much fucking cash around? And why is it stapled? Fitzpatrick said Charles staples his money in $1,000 increments. I have so many questions for the IRS. Excuse me, feds, How much cash is Charlie running through? Is he taking discounts at the office if people pay with cash so he's not reporting it? I have questions. That is pure speculation. I know nothing about any of it, but this is a lot of cash moving around frequently. Also, if the money is being kept in $1,000 increments and they're hundreds, it's actually not that much to staple together. But what the fuck is with the stapling money? I have so many questions. In October 2019, Garcia was tried and convicted. He was sentenced to life in prison. In April 2022, after the clarified audio recording from Dolce Vita revealed Charles making additional incriminating statements, he was arrested for first-degree murder, solicitation to commit first-degree murder, and conspiracy to commit first-degree murder. In May 2022, Catherine McBanawal was tried and convicted. She was sentenced to life in prison. In October 2022 and November 2022, the proffers previously mentioned were conducted with Catherine McBanawal. In October 2023, trial for Charles Adelson commenced. On November 6, 2023, Charles Adelson was found guilty on all charges. I know when I said this trial was like 2 years ago, you guys are like, this just happened. Nope. 2 years ago, which is wild. He is sentenced in October 2023, trial for Charles commenced. On November 6, 2023, Charles Adelson was found guilty on all charges. He's set to be sentenced in December 2023. Remember, this is before his sentencing because Donna had a flight to catch. In Adelson's trial, McBanawal testified that Adelson told her that his mother, Donna Sue Adelson, had just departed his residence at the time McBanawal arrived on the night of the homicide. McBanawal said the money she received appeared to have been washed. Jail calls, which are on the playlist if you hadn't heard them. There was much litigation over this. Jail calls from Charles Adelson's guilty verdict include multiple calls in which Donna Sue Adelson is telling Charles Adelson that she is getting things in order, creating trust, and making sure her grandchildren are taken care of. Donna discusses plans for self-harm, which I can't say that word on YouTube because this video will get yeeted, but she discusses whether or not she wishes to exist, but also discusses plans to flee to a non-extradition country. Remember, Donna Adelson's going to testify that she wasn't fleeing. She just didn't want to be extradited. It was just a one-way ticket. Donna Sue Adelson has considerable financial resources to accomplish this. On November 7th, 2023, Donna and Harvey Adelson booked flights to Vietnam with a stop in Dubai. The flight departs Miami, Florida, November 13th, 2023 at 8:10 p.m. to Dubai. The flight departs Dubai November 15th at 9:35 a.m. and lands in Saigon at 7:35 a.m. Signed by Judge 13th day of November 2023. So they were racing to do this like tick-tock on the clock as the flight was getting ready to depart, and they popped her at the airport and then perp walked her through the airport. Judge Stephen Everett is like, probable cause is sufficient. All of you are saying, but who doesn't want faux? I mean, fantastic. And yes. But no. So this is the warrant for arrest for capital murder. Date of birth, 2/5/1950. Let's see. So this is signed by the judge to go arrest Donna. Is there a time on this? November 13th, 2023 at 5:45 p.m. The flight departs at 8:10 p.m. They found out really close in time that Donna was leaving. I wonder if somebody else booked the flights and it didn't ping, because that is close in time. Night 10:07 said, judge working late. Look, judges will work after time on warrants, but if they went into the office and were like, let me explain why we need to arrest Donna. This is right after Charlie's been convicted, before he's even been sentenced. And they go to Judge Everett and are like, let me explain why we need to arrest Donna. I imagine Judge Everett was just like, I'm listening. And then they're like, blah, 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 blah. And the call afterwards, blah, 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 blah. One-way ticket, blah, 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 blah. And he's like, go get her. And then they would have needed to contact Miami and get Miami to arrest her because this was signed in Tallahassee. And they would need to fax it to Miami and be like, we need you to go arrest her. But she almost made it out. Like, real close. Some of you are saying, what if Judge Everett wasn't around? Oh, no, this is a call the judge on their cell phone. This is a call the judge on their cell phone for this arrest situation. And yes, that does happen. This is a, Your Honor, emergency. I'm sure we'll hear that call again in trial. I covered it. It's on the playlist, but look at how close in time that is. 5:45 is when it was stamped. It was probably signed maybe 15 minutes before it's stamped, but this is still happening after 5 p.m., just hours before her flight. She probably thought she was clear. This one is stamped at 5:46. She got arrested in Miami, as we know, and then transported back to, these are all the other warrants, and then transported back to Leon County. So, Donna almost made it out. For those of you that did not know about this case, what are you thinking? There's like 21, with over 11,000 votes, there's like 21% of you that are like, I don't know this case. And then there's 29% of you who are like, I've seen you talk about it, Emily, but we haven't talked about it in this much depth in a while. Yeah. Oh, for those of you in the chat that are like, I bet they were talking to Miami while they were talking to the judge, 100%. No, 100%, because they knew they had enough. And she was so mad. And then she tried to play it off. Like, we heard the jail call with Charlie where she's like, I'm making all these plans, whatever. And then they come and she's like, what is this about? Don't take my cell phone. Don't touch me. She was just like trying to play it off like it wasn't a thing. Ma'am, you knew exactly what they were there for. Why are you touching me? Please. It'll be interesting to see if they play the arrest video in trial of her being like, I have no idea what you're talking about. We'll see. We have a few more documents to cover. I've been saving your questions. Do not worry. But for those of you that are like, is this even real? Yeah. But the prosecution has done this trial numerous times now, and they are going to move through this information pretty quickly. But when they lay all of this out, the unknowns are, what is Charlie Adelson going to say? Is Charlie Adelson going to be like, this is all the times I talked to my mom and this is what I knew? Is Charlie Adelson going to plead the fifth? Is he even going to be called to testify? Because he still has appeals. We know Catherine McBanawel's appeals have run. Garcia and Rivera's appeals have run. Wendi doesn't have a Fifth Amendment privilege because she has immunity with regard to her testimony. Is Catherine McBanawel going to throw everybody under the bus even more? She's like, if I'm sitting here for life, y'all can sit here for life. Fuck all y'all. We're going to see. We're going to see. All right. So this is in jury selection now. When it starts, well, it depends on how fast they get a jury. We'll see. I'm very interested. I saw a question about immunity. Crime Trial Addict said, with immunity, can they still charge her? Yes, but they cannot use what she said in testimony. They can use what other people said in testimony. They can use her police interviews, but they cannot use what she says in court in testimony. So that they can't. Maria Robb said, I still can't believe Catherine McBanawel did not take the plea deal they offered. I don't know what information people were getting. I don't know if we can speculate more after the trial. I don't know if people thought it was going to be handled. Like, oh no, it'll get handled. The thing is, at some point, you've got to protect yourself. Mango Jelly asked, isn't that how Bill Cosby got released? Yes, because they tried to use something that he had immunity for against him. And they're like, you can't do that. You can't make a promise and then take it away and then use it against somebody. Not going to work. So they can't use what Wendi says in trial. It's pretty easy to isolate what she says in trial, but they can use everything surrounding it. And there's a lot surrounding it. But again, vibes that somebody's involved and proving that somebody's involved are different things. Also, the prosecution has chosen, and I really would love to talk to the prosecutor about that whenever these prosecutions are done. The prosecution has chosen to go one by one by one. And I wonder if it's because they want Wendi to testify about all of this. I mean, Wendi's statements to police are pretty telling, aren't they? We'll see if they ever charge Wendi. Maybe they will, maybe they won't. I don't know. I'm interested to think, I'm interested to see how it goes in this trial. And then maybe if we ever have some time, we will revisit all the rest of it. Sleepy Vapor said she was offered full immunity. I don't know if she has full immunity because when the defense is asking to subpoena her, she said the defense cannot offer me immunity. I think she only has use immunity for her testimony. I don't think she has full immunity. If she had full immunity, there'd be no reason to quash the defense subpoena because the defense could just call her because she had been granted full immunity. There'd be no reason to fight it. And the defense would have said she doesn't have a Fifth Amendment right. In the hearing today, the defense said, we agree she has a Fifth Amendment right. And if called to testify, she'd plead the Fifth. If she had been granted full immunity, she would not have a Fifth Amendment right. She only has use immunity for what she says under subpoena by the prosecution. Otherwise, it would have come up in court and today would have been moot. So she does not have full immunity based on everything that we saw go down in court today. Continuing, we have two other motions. So let's get to motions, shall we? One of them is regarding Jailhouse Informants. One of them is regarding Wendi. I think we'll do the Jailhouse Informants first, and I'm going to go over Wendi a little bit more quickly just because we heard the oral argument on Wendi's motion in court, but we did not go over the new motion regarding the informants. So this is a redacted motion to suppress. It is not as redacted as prior motions were. So let me pull this up, and then we're all going to just go, oh, when the documents pull up and are glorious and easy to read. Look at that. It's just like, all right. This is the redacted defense motion to suppress. This was filed on August 13th, 2025. I will look at the docket today before we finish and see if there's anything new that we need to know about. But this was last Wednesday. So let's see what they have to say, because there's more tea in this. I covered the last filing and it was way more redacted than this one was. So, Defendant Wendi Adelson, by and through undersigned counsel pursuant to Article 1, Section 12 of the Florida Constitution and the 6th and 4th. Oh, I didn't swoop. Chat, you're right. Sorry, my bad. Hold on. I clicked too fast. That was better. I know. We have new toys. On November 15th, 2023, Ms. Adelson was indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. On April 7th, 2025, the state disclosed the existence of two jailhouse informants, including Drina Bernhardt. Not redacted. Although recordings of her interviews with law enforcement were provided, the undersigned was unable to depose Ms. Bernhardt until August 11th, so 2 days before this was filed, because Bernhardt had violated her probation and pretrial release conditions and could not be located. That's not good. I wonder if Bernhardt is back in custody now, because if she was released pre-trial and couldn't be located, law enforcement's not going to like that. Keep reading, Emily. Bernhardt was arrested on her warrants on August 5th, and the undersigned promptly scheduled her deposition. Right. We can't find her. Oh, found her. Ma'am, if you're working with law enforcement, don't bounce. It's just going to agitate them. On August 12th, the state disclosed another witness, Mickey Easterwood, aka Mickey Lang, who was also incarcerated with Adelson and Bernhardt, and provided a recorded interview which took place on August 11th, 2025. Look, is the investigation done yet? No. No, it's not. So, August 11th, 2025, recorded interview with Jason Newland and Special Agent Patrick Sanford. I'm sure some of you will ask, Emily, is this late discovery? Shouldn't they do this sooner? If it just comes to their attention, it's not late if it's turned over when it happens. And look, this interview took place on August 11th. When did the defense find out about it, chat? August 12th. The next day. Hey, we just did this interview. Here is this interview. And the defense filed this the day after. They turned it over the next day. During this interview, among other statements, Ms. Eastwood disclosed that rather than Bernhardt merely listening to Adelson make statements about her case, Bernhardt also asked Adelson questions. So this is going to get into whether or not it's appropriate for someone working with law enforcement as an informant to start questioning someone. However, what we've heard from the prosecutors is that they aren't necessarily going to use these informants at trial. So the defense is making a motion to suppress. This is what I think was heard yesterday in camera by the judge, because there is stuff that's redacted here. But the last time they were in court on this, the prosecution said, we don't seek to introduce any of this, though things may have changed. Mel DB in the chat said, will her daughter testify in her trial? Yes, but I don't think Wendi will testify for Donna. Wendy's going to be called by the prosecution. So, as a result of Bernhardt acting as an agent of the state, Ms. Adelson moves to suppress any statements Adelson made after December 20th, 2024. Statement of relevant facts. And this is more than we knew because the last motion was so redacted. This one is much less redacted. Bernhardt testified she met Adelson in the annex. According to jail records, Adelson was initially moved into the annex in August 2024. Bernhardt was arrested for a violation of probation and new charge on September 18th, 2024. Excuse me. On December 5th, 2024, Bernhardt was initially interviewed by Detective Joshua Turner of the Leon County Sheriff's Office. During the interview, Turner provided Bernhardt with his contact information. Subsequent to this interview, Bernhardt wrote a letter to Turner, which he received through interoffice mail. A copy of the letter is attached and incorporated as Exhibit A. That is redacted, so we won't see it. On December 18th, Turner again interviewed Bernhardt. During this interview, Bernhardt provided LCSO with information about a human trafficking case and the Adelson case. So Bernhardt is giving law enforcement information about cases that she is presumably learning while in custody. On December 18th, 2024, after that December 18th, 2024 interview, Turner contacted investigator Jason Newland, who's in charge of the Adelson case. On December 20th, 2024, Bernhardt was brought to the state attorney's office to be interviewed. During that interview, Bernhardt confirmed her current plea offer was 5 to 6 years. During her deposition, Bernhardt conceded that she was both a violent felony offender of special concern and qualified for sentencing as a prison releasee reoffender. The statements Bernhardt made are addressed in the previously filed July 29th, 2025 motion in limine, and transcripts of those interviews have been previously provided to the court. That was the filing that we went over that was like just sentence redacted, sentence redacted, sentence redacted. Bernhardt told the state on December 20th, 2024 that Adelson called Bernhardt her jail daughter. I wonder what Wendi thinks about that. During the recorded interviews, Emily, now you're just being rude. Well, I'm actually curious that Donna has adopted some new kids in custody. I wonder how much Donna and Wendi have talked since Donna's been in custody. Because I imagine that Wendy's going to be asked about it. I imagine that Donna's going to talk about it when she testifies, but we'll have to wait and see. During the recorded interviews, law enforcement told Bernhardt not to ask Adelson questions and just listen to whatever Adelson said about the case. Specifically, Newland stated, quote, "So you cannot be an agent for us. I can't send you in there to ask her any questions. Quote, listen, if she has a casual conversation with you, there's nothing stopping you from having a conversation with her. Don't make things weird. Quote, don't initiate any of these conversations." If someone is working with law enforcement, they can't go in there and be like, "So did you do it?" Now, if they're not working with law enforcement, they can ask whatever the fuck they want. But once they're working with law enforcement, they can't become agents of the state. And there is case law regarding jailhouse informants and the rest of it. Newland continued, stating, quote, "This is one of the biggest things that is to come out of this meeting with us is, quote, don't make it awkward." Emphasis added. "But definitely do not go back there on our behalf thinking you need to give us more information." Because you see where the concern is, right? If somebody wants to reduce their sentence, they're going to go in there and be like, "Oh, I'll interrogate, so I'll get all the tea." They can't do that. But if Donna's being a chatty Cathy, there's nothing to stop people from listening and sharing that information with anyone. Bernhardt testified that she provided written documents to Turner of what Adelson instructed Bernhardt to say when testifying on 10 different occasions. Let me read that again. This was redacted out of the last one. Let me read that again. Bernhardt, in her deposition, said that she provided written documents to Turner of what Adelson asked/instructed Bernhardt to say when testifying. And we had heard reports that Donna was asking people to testify on her behalf and was telling them what to say. And we're seeing that here too. She later testified this happened more than 10 times, footnote 2. Turner testified in his deposition this took place once or twice. During her August 11th, 2025 deposition, Bernhardt initially claimed she did not ask Adelson any questions, but later said that she did ask Adelson questions. The fact that Bernhardt engaged in conversations rather than just acting as a listening post with Adelson is corroborated by a subsequently identified witness. On August 11th, 2025, Mickey Easterwood informed law enforcement, I said that weird, I don't know why, informed law enforcement that Bernhardt questioned and manipulated Adelson. Interesting. Elaine said, "Be cool. Don't be all like uncool." I know, it's very Real Housewives coded. So now we've got somebody else saying, no. Bernhardt was manipulating Donna Adelson. During the August 11th, 2025 interview, Easterwood said that, quote, "It was very obvious that she was trying to get information out of Donna. Instead of acting as a listening post, Bernhardt was not merely a passive listener. Rather, she continued to engage in conversations with Adelson. Statements purportedly made by Adelson after December 20th, 2025 were a product of these conversations. The state's desire to elicit additional statements from Adelson resulted in 3 additional recorded interviews with Bernhardt, January 13th, January 29th, and February 11th, all 2025. Discussion of law. In U.S. versus Henry, the Supreme Court held that law enforcement cannot deliberately elicit conversation with a defendant in order to elicit incriminating information. The Sixth Amendment prohibits law enforcement officers from deliberately eliciting statements from a defendant after the right to counsel has attached. The right to counsel has attached here. You can't just end route an interview by using somebody in custody. So they are bringing up the law, talking about that. Now, if somebody says, "I want a lawyer," and law enforcement says, "Okay, it's going to take us a minute to get you transported back to wherever," and then the person starts talking again, that's different. But if law enforcement asks a question, then that's violative of their right to counsel. The case law here that they're quoting says, passivity on the part of law enforcement is a critical factor in the analysis. A knowing exploitation by the state of an opportunity to confront the accused without counsel being present is as much a breach of the state's obligation not to circumvent the right to the assistance of counsel as is the intentional creation of such an opportunity. So the case law that they're getting into is going to get into jailhouse informants and how they can be used, how they can't be used. These operations can be done properly. They can also be done improperly. I'm not going to go through all the case law on this because the prosecution's already indicated they're not going to use these conversations. However, this might come up if Donna testifies as impeachment, if Donna says something that's contradicted by these jailhouse conversations. So this could come up in impeachment, but this all happened in a sealed hearing. The defense is alleging that law enforcement violated Adelson's Sixth Amendment by these conversations and, quote, by sending Bernhardt back into the jail with the stated purpose of obtaining additional information from Adelson. The state authorized Bernhardt's action is the argument by defense. By further allowing Bernhardt to benefit from her continued conversation with Adelson, her probation was reinstated instead of the 15-year prison sentence or prison release reoffender sentence or the purported 5 to 6 year offer. The state incentivized Bernhardt's continued actions on the state's behalf. Look, they're going to give her a better deal. She has a reason to continue to try to get more information because she's benefiting from it. So they are arguing that none of that comes in. We're not going to really know what the court ruled unless we see a written ruling or it comes up after Donna testifies, because this would only come up as impeachment at this point. So the defense goes on to argue that this is a Sixth Amendment violation. It's shown because the defendant has established the informant and authorizees had a pre-existing plan for the informant to obtain a confession. A Sixth Amendment violation is established in this case for any statements made by Adelson after December 20th, 2024. Their conclusion is that based on the foregoing, the state violated Adelson's Sixth Amendment rights, and the court should suppress the statements Bernhardt claims Adelson made after December 20th. Again, we'll see if this comes up. Just for clarity, these are the exhibits. And they are redacted. Bubbles in the chat said Googling quote unquote laundered money is too hard for her. No, Bubbles. I think Donna was like, well, they can get your Google searches. I think they were trying to stay away from Google. We'll see. So let's just briefly, before we get to questions, we're going to briefly go over the last document, which is Wendi Adelson's motion to quash. Wendi is like, I'm not testifying on behalf of dear old mom. And we saw the court grant that earlier today. And then I will just take a peek in and see if anything else is going on in court. And then we will continue. So let's pull up. This is a 27-page motion. We are not going through all of it. We heard most of the arguments. So we need to swoop again. The swoop's working well. We'll just swoop again. I know it looks so clear and so crisp, so fresh and so clean. All right, this was filed on August 13th, 2025. We're getting all caught up on the Adelson case today. I don't know what we're going to talk about tomorrow. Today, all Adelson. Tomorrow, we'll see. I mean, if they have a jury, who knows? I wanted to make sure we got this done before trial started. Non-party Wendi J. Adelson's motion for permission to place a statement on the record and to quash the defense subpoena. Non-party Wendi J. Adelson is the daughter of defendant Donna. Oh, we're well aware of who Wendi is. The daughter of defendant Donna Adelson is expected to be one of the first witnesses called by the state in Donna Adelson's trial, which is really, really going to fuck with my travel. But we're going to, fingers crossed. Both the state and the defendant issued trial subpoenas to Wendi Adelson. By law, the state subpoena confers immunity on Wendi Adelson. That's by law in Florida. That is not the same in every jurisdiction. If you get subpoenaed by the prosecution, you need to make sure that you understand what is offered and what is not offered, because it is not necessarily offered in every single case. Miguelina, just so you know, my starred chat are the only chats I have. Everything else disappeared as we are testing things ahead of trial. But everything except my saved chats are gone in the live chat tab. Again, kicking the tires. But the sound, the clarity, it's worth it because I still can see you guys over here. Cub in the chat said the fact that Donna didn't Google luxury prisons for rich is interesting. Yeah, she was on to Google. Right? So Wendy's expected to testify. Wendi says that by law, the state subpoena confers immunity on Wendi. The defendant's subpoena does not. Accordingly, Wendi respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena and to quash the trial subpoena issued by the defendant, Donna. In support of this motion, Wendi Adelson states as follows. Donna Adelson is charged by indictment with first-degree murder, alleging that she participated in a conspiracy to murder Dan Markel, Wendi Adelson's ex-husband, on July 18th, 2014. Other alleged members of the conspiracy, they've been convicted. Other alleged members of the conspiracy were charged and convicted, including Catherine McBanois. In the McBanois trial, both the state and defendant subpoena Wendi Adelson to testify. In response, Wendi filed a motion like this one to place a statement on the record and to quash the defense subpoena. Thus, the two trial subpoenas by each party in this case present the same issue the court dealt with in the previous trial. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights. We've been talking about that. But by law in Florida, the state subpoena means that you cannot use the things that Wendi Adelson says in court against her, but you also cannot use the things Wendi says in court to go get a subpoena for documents or to use it in any way. So use and derivative use immunity, you can't use the shit she said in court. You can't use it to investigate her. You can't use it against her. But the defense subpoena does not do that. In the McBanois trial, the court quashed the defense subpoena and granted Wendi Adelson's attorney an opportunity to place a statement on the record. See the transcript. We request the court grant the same relief. Footnote 2. In the related hearing before the court in the McBanois trial, McBanois counsel argued that it would be reversible error for McBanois cross-examination to be limited because the state can tailor their direct examination to prohibit McBanois from going into areas that could potentially be relevant. Based on dicta, I put an A there, but based on dicta by the First District Court of Appeal in McBanois' appeal of the prior protective order prohibiting the deposition of Wendi Adelson, in that opinion, the first DCA did acknowledge that McBanois would be given little latitude in cross-examination of Adelson because her questions would be limited to the narrow categories of information the state elicits. However, the first DCA, District Court of Appeal, did not grant McBanois relief requested in that appeal and recognized that, quote, when the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances such as these, the Sixth Amendment right must yield because to require one to incriminate himself in order to afford another or in order to afford help to another would be both unwise and unrealistic. So the appellate court said, no, you can't force someone to incriminate themselves and incriminate themselves. Like you can't make them testify against themselves, even though you have a right to confront and cross-examination. But the right to confront and cross-examination, as I see it, still exists. Not as fulsomely as the defense would like, I'm sure, but anything the prosecution asks, the defense can cross-examine on. So you have a right to cross-examine. It's just maybe not as thorough as you would with other defendants or other witnesses, I should say. So, continuing on, dicta, by the way, means non-binding language in the court record, though I do appreciate all of you in the chat saying, "Da Bears." Continuing on, it says, however, the first DCA did not grant McBanois requested relief in that appeal and recognized that When the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances such as these, the Sixth Amendment must yield. I am rereading that. And just this past month, the first DCA again addressed these same arguments by McBanois. The first DCA found no error in the court's handling of Wendi Adelson's trial testimony, favorably cited Wendi Adelson's counsel's statement on the record, and concluded, quote, the trial court properly ruled that she could not be called as a defense witness. So McBanois' appellate rights literally just concluded July 2nd, 2025. McBanois may be all out of fucks by the time she testifies in this trial. It's going to be real interesting to see if she has any, like, how many fucks do I give? How many fucks do I give? How many fucks do I give? 0, 0, 0, none. I mean, McBanois' appeals seem to be done. The defense for Wendi Adelson goes, or the attorneys for Wendi Adelson goes on to say there is no reason to depart from the procedure employed by the court in the McBanois trial. Again, courts don't want to do anything weird. The court was upheld. The court's going to follow what the prior court did. In the McBanois trial, the court scheduled a hearing related to this requested relief just prior to Wendi Adelson's testimony. Wendi respectfully requests the court set a similar hearing on this motion outside the presence of the jury prior to her testimony or at such time determined appropriate by the court, and they did that yesterday. All right, nothing left on that footnote. It's a footnote that took up half the freaking page, but the court did that. Memorandum of law, the court should allow Wendi Adelson's attorney to place a statement on the record regarding the state subpoena. Wendi Adelson will testify pursuant to state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment. As a result, Wendi requests that once the state calls her as a witness, her counsel should be allowed to place on the record a statement outside the presence of the jury that, 1, Wendi Adelson intends to invoke her Fifth Amendment and Section 9 rights. 2, Wendi Adelson's testimony is entitled to use and derivative use immunity pursuant to Florida Statute 914.04, footnote 3. We're not going to read the statute. And 3, use and derivative use immunity extends to any testimony given during Donna Adelson's cross-examination of Wendi Adelson. Her lawyers are like, we are going to cover her ass. And it's going to be on the record that none of this can be used against her. They have to be concerned, right? Given the state's theory of the case, there is no question that Wendi Adelson has a real and substantial interest in asserting her rights against compelled testimony. Excuse me, Your Honor, but have you seen the facts in this case? Wendy's not being dramatic. She has a reason to be concerned. Given the state's theory of the case, there's no question that Wendi Adelson has a real, substantial interest in asserting her rights. To ensure full protection of Wendy's rights, it goes on, she respectfully requests the opportunity to state on the record her entitlement to these important constitutional and statutory rights. They argue the court should quash the defense subpoena, which they're going to do, and then concludes. And then in the exhibitees, there are subpoenas. There is a hearing from May 19th, 2022 from the hearing in the McBanois trial. And that is the rest of the testimony, or the rest of the pages here is that transcript, which we're not going to go over. And parts of other transcripts in the McBanois trial. So what do we know about Wendi? 1, she's worried. 2, she has a limited use and derivative use immunity. What she says and derivatives therefrom can't be used against her. We know she's going to testify at trial. The defense wants to call her. The most interesting thing in court for me was that when the defense was saying, we want to call her, the defense was saying, but Donna Adelson is Wendi's mother. She knows more about Wendi than Catherine McBanois does, and she wants to question her. So I don't know, chat. Shots fired? Like, Donna's attorneys are like, oh no. The questions we want to ask are substantially different than the questions Catherine McBanois would ask. Because Donna knows. That's going to be real interesting. Going to be real interesting, isn't it? This trial is going to be an interesting one to watch. We are going to get to questions real quick. I'm going to check in and see if anything is going on in court real fast. Let's see. It just looks like, a whole lot of, let's see. We're going to scrub around a little bit. Let's see if we can. Let's see if I can back up. Nope. It will not let me. We're going to have to restream because it will not. Miguelina told me that earlier. Let's look. All right, chat. I'm going to pull this up and we're going to look together. This is not going to be a smooth process. I don't want to get distracted by other chat, but it was letting me scrub. And now, nope. No rewind at all. Okay. So let me find one more. I knew that. I was optimistic that maybe something had changed. We'll handle that tomorrow. But let me see if there's anything else, because I know the court went to lunch. I just want to see what the court said when they came back from lunch. So we'll find that real fast, and then we'll get to Q&A, because there's going to be a lot of other streams of this where we can just rewind real quick. So I'll go grab it. I don't need to grab mine. Thank you, YouTube, for pulling mine up. I appreciate that, but let's find one that doesn't have 100,000 different tickers on it, because that's not what we need. Well, let's see if we can find. Let's see if we can find what the court said when they came back from lunch, which I do not see anywhere. Okay, hold on. Let me grab this. Let me grab this real quick. So we're going to look at what the court says when they come back from lunch real briefly, and that's going to be it for court today. So we're going to go back to court just for a few minutes. Let's see. Oh, that has a ticker too. Hold on. I'll find one. It's just going to take me a second. Tomorrow we'll have a different solution, but I'm glad we have some of it. So thank you, chat, because live streaming is dynamic. But we'll find it. So not a worry. I'm very picky. It's full Goldilocks mode. It's like, this one has too much stuff on the screen. That one has too much of a ticker. This one doesn't have closed captioning. That one doesn't rewind. It is full. This one's not this. This one's not that. Let me see if they put up another video real quick, because they had done one of back from lunch. No, that was 6 hours ago. All right. Well, we will deal with the most minimal intrusions we can deal with. And then tomorrow I will just grab my own. Because, planning. We'll just grab our own tomorrow. I don't know what we're going to, it depends on where we end the day today to where we go tomorrow. So we will see. But let me pull this up and see what the court has to say real quick. We are going to go to live court. Yay, court. Let me make sure we have volume. We have volume. I know you all missed the fan. We do not have fan.
At this point.
There we go. Judge is back on the bench. Fantastic. Let's see what the judge has to say. At least the microphones don't sound deep fried today. That's fantastic.
We're just waiting on the jurors to return at 1:45 at this point.
Okay.
Are there any matters that we need to address before we continue?
I've got this cropped like the document feed, which is just easier to see.
Yes.
The attorney's asked to approach. We'll see if they go to sidebar. If they do, I'll just zoom because immediately sidebar. Sidebar. Now the court reporter will hear all of this at sidebar because there's microphones there. We will not. We never hear the sidebars. Sometimes we get the transcript, sometimes we don't, but you can see the defense attorney holding a microphone for that. So and then the court. At least we can see the attorneys at sidebar, but we're going to zoom past sidebar effectively, hopefully. Sorry for the pointer over your face, Your Honor. My apologies. Huh. Why sidebar when no one is in court? Doctor Who asked. Because the cameras are still in court and there are things that need to happen off of the public view. So that is why. So they cut the cameras for a moment. I don't know if that's because the jury was coming back in. We'll find out real quick. We're going to zoom. The judge is just working. So we're getting co-working with the court. Let's see if he goes on the record at all. Or if they go right back. Let's see what he puts on the record. Because the jury's coming back in from lunch and they're going to keep picking. They're going to keep picking. So Kiki said, what are we looking at now? We're just looking at after lunch today during jury selection to see if the court puts anything on the record. And because the feed I was going to use has no rewind, we just grabbed another feed real quick. But tomorrow we'll just have a feed. We'll just save our own. So I don't see anything back on the record. Oh, there's the judge. We're just seeing what the judge puts on the record afternoon. The jury's coming back in. So why not? And I like this judge. So I'm happy to see more of this judge on the bench. He says, good afternoon. And they're like, good afternoon. And he's like, that is insufficient.
Take two. Good afternoon, ladies and gentlemen. Thank you.
Much better.
I'm Stephen Everett, one of your judges in the Felony Criminal Division.
This is not the group from the morning. This is a new group. So they don't know yet. They hadn't learned yet, right? They hadn't learned yet.
Here in Leon County. You have been summoned here this afternoon as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process today that I will be reading to you. It is not that I do not wish to have a free-flowing conversation, but rather any explanations on the law that you
so
will
if all of you are like,
throughout
Emily,
this process must be unified.
This is exactly what the judge said this morning. Yes. And he's advising them that he's saying exactly what he said this morning. It may not seem like we're having a conversation. The law requires me to read this exactly the same for every juror. It's really hard to say the exact same thing to two separate groups of people every day for 3, 4, or more days without reading a script. So he's like, yes, I have to read a script. It is part of making sure every juror that comes before the court is told the exact same thing. So he is telling the afternoon group the exact same thing.
Form and must be specific according to the Florida Supreme Court. Is the state ready to select a jury this afternoon?
Yes, Your Honor.
Is the defense ready to proceed as well? Yes, Your Honor. And for the record, I'm noting that the defendant is present in the courtroom with her counsel. I believe earlier this afternoon, Judge Riggins qualified everyone. However, I am going to confirm
the new group
with the qualification if there is anyone that needs to be excused on a statutory basis. That will happen before we move on through our process this afternoon. When I ask the following questions, please raise your hands if you are responding yes to the questions. Is everyone here that is a prospective juror at least 18 years of age or older? Please raise your hands if you're over 18.
Same as this morning, right?
For the record, I will find that the prospective jurors have answered in the affirmative. Is everyone here a citizen of the United States of America?
So again, same as
Once
this morning.
again, for the record, the prospective jurors have
Which is what we
answered in the
expect.
affirmative. Is everyone here that is a prospective juror a resident of Leon County? Again, the prospective jurors have answered in the affirmative. Do each of the prospective jurors possess a driver's license or identification card that's been issued by the Department of Highway Safety and Motor Vehicle? Or have you executed an affidavit as to your eligibility to serve as a juror? Once again, the prospective jurors have answered in the affirmative. Once again, please raise your hand if your answer is yes to any of the questions that now follow. Has anyone been convicted in a state or federal court of a felony crime or a crime involving dishonesty, and your rights, your civil rights have
So
not
exactly
been
what he
restored
said
to you?
this morning. I'm going to put him at 1.25. We appreciate you, Your Honor.
None of
You
the
speak
prospective jurors have raised their
so
hands in the
clearly.
affirmative.
I just want to see if he says
At
anything
this
different than
time,
before.
is anyone under prosecution for any crime, either in a state or a federal court?
Same as we heard today.
No hands have been raised for the record. The next grouping of items that I'm going to go over are people that may be excused by statute for falling into a specific grouping or class. If you can go ahead and silence your cell phones at this time.
That's a
After I ask the
problem.
question, if you are responding
At least it was only a ping on the cell phone. It wasn't a full like, "My milk truck bring all the boys to the yard," and they're like, "Oh, better than." At least it was just a small ping.
to this particular basis to be excused, please raise your hand and I will address you separately in just a few moments. Is anyone a full-time sworn federal, state, or local law enforcement officer or investigative personnel? Please raise your hand if this applies to you. No hands have been raised in response to the question. Is anyone an expecting mother or a parent responsible for the full-time care of a child that is under 6 years of age, and there is no one else to take care of the child? No hands have been
Yep,
raised in
same as
response to the
today.
question. Is anyone present 70 years of age or older? No response has been given to the question. Has anyone performed state jury service within the last year? The last year meaning August 19th, 2024 to today.
No? Good.
No hands have
Everybody
been
good?
raised in response.
Great. We're glad we're good.
Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves? And you being here today will create a hardship for them.
Ori in the chat asked, and I'm having a hard time grabbing the chat to put up on the screen, but asked, what does it mean? And your rights have not been restored. After a felony conviction, you can have rights restored, voting rights and other rights, and then you can serve on a jury. But if that has not happened, then you can't. People generally know if that applies to them and fill it out on the questionnaire before they even go into court. This is the court covering all bases like 3 times.
No hands have been raised in response. Is anyone a full-time student between the ages
Also,
of 18
Emily in
and
the chat
21?
said, I'm surprised nobody raised their hand over 70. Again, they already did questionnaires, so you can put those things on the questionnaire before you even come to court, and you'll get sorted at the questionnaire stage and not even be called in. They do the questionnaires first, then they sort them, then they call in groups of 50, and then stagger those groups of 50 after the questionnaires. So it would have generally filtered everybody out before you get there.
Who is attending high
And
school
no, Dr.
and
B has
state
not responded to
university,
text or call. I don't know what he's up to.
post-secondary
He's doing
educational
something.
institution, Florida college system institution.
We're not
or
surprised at
career
this
center.
point.
Please raise your hand. All right. We'll address you in just a moment. Are there anyone else in the back?
So full-time students,
One hand is raised in response.
some hands.
Lastly,
And then this is a new edition.
has anyone given birth within the 6 months before your reporting date on the summons, which would be today? Please raise your hands. No response has been given.
Okay.
Right, the one hand that was raised, please approach the bench.
All right. So they're going to approach. The cameras are going to go to the only vent or the only flag. And then they're going to resume jury selection. Let's see what the judge says
Discuss what some of you
when he takes the bench, which we did not see this morning. and then they're going to continue jury selection. I don't know if we will see a jury
First
picked
thing
in the
that
next
we're
2
going to do
days.
this afternoon
We'll
is
see.
discuss what some of you may know about this case. This case has received some publicity in the past, and there has also been a related case that was tried nearly 2 years ago. This process is going to be handled individually because you all don't need to know what the others may know about this case.
That's what I said today.
However, before we start
Can't
the
put the shit back in
questioning,
the
I'm
horse.
going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices that you have brought with you. Even though you have not yet been selected as a juror
Fred is
in
yelling at
this
me.
trial, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward.
This is not a case
You
that
must
pops up
not
on my
use your
feed, but
phones
I'm
or
not local to
devices
Florida.
search the internet or to find out any information that is related to this case.
Hi, Fred.
Between now
For
and
new
when you have
Leonards,
been
Fred is
discharged
one
from
of my
jury
cats.
duty in this matter, you must not provide or
Fred is one of Travis's cats. I am occasionally the human that he will put up with if nobody else is around. For those of you asking about George, George is Fred's brother. George, yesterday, when Travis came home, went meowing towards the door so fast, it was like Travis had never been gone. So Travis and George are now back to where they were before Travis left for the summer for DCI. So it took about a week, and George is like, okay, fine, my human is back. So yesterday, George was like, fine, and was just meowing towards the door when Travis came home like he does almost every day. So George is like, all right, you're not going to leave again. I've forgiven you. It's fair. So back to being the happy cat that he is now that Travis is home. All right, back to Judge Everett and the jurors.
or receive any information about your jury service to anyone, including your friends.
Don't search the
coworkers,
internet.
and
Don't tell
family
your friends
members.
you're jurors on this trial.
You may tell those who need to know where you are. That
You could
have
say
been
you're on
called
jury
for
duty. That's it.
If you are picked for this jury,
You
you may
can
tell
say how
people that
long the
you've been
case is.
selected for the jury and
That's
how
it.
long the case may take. However,
Nothing
you
else.
must not give anyone any information about the case itself or the people that are involved in this case.
Oh my God, Basti. I got picked for jury duty on the Donna Adelson murder case. Can you believe it? You can't do that. Mm-mm. You can call up work and say, I've been selected for jury duty. The case is expected to be done on this date. If you need any further details, call this courtroom, because the courtroom clerk normally gives them a card or a number. Like if your employers need any information, call the court clerk. There it is. That's it. Not the charges, not the defendant's name, not who the lawyers are. I'm on jury duty. It's going to last this long. Though anyone watching this case would be like, I think I know what that is.
You must also warn people not to try to say anything to you or to write to you about your jury service or the case.
Well, Lawnards, you can.
This
You're not on jury
includes
duty. You're on
face-to-face
Lawnard jury duty.
communications,
You can tell everyone
phone
you're on
or
jury duty.
computer communications as well.
Oh, guys, do we need a note for jury duty? Because I saw that like Travis Kelce was giving notes for work because Taylor Swift was on his podcast. We have trial on our podcast. I feel like we can do work notes. I mean, if Travis Kelce can give work notes, I feel like we can give work notes. So I feel like we can do jury duty notes. All of you are like, yes, we need work notes. I'll work on it.
In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case. This includes tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all.
You can tell when
Do
that
not
was
send
written.
or accept any messages, including email and text messages about your jury service. You must not disclose your thoughts about this case or your jury service, or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about this case until you have been excused by the court. Avoid the newspaper and television broadcasts, particularly the local news stations. Also,
Particularly
avoid social
local
media
news.
or any internet news sites. I am now going to provide to you a statement of the case that has been agreed upon by the parties. On July 18, 2014, FSU College of Law professor Dan Markell was shot while seated in his car. This happened in the driveway of Markell's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markell and has entered a plea of not guilty. I will also now read to you the material part of the indictment that has been filed against the defendant.
That's what we read today. If you haven't heard of this case, are you sitting on this jury going, holy shit, T,
Count one.
like, what?
It is alleged that on or about July 18 of 2014, Donna S. Adelson in the county Leon and state of Florida did unlawfully kill a human being, Daniel Markell, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markell, contrary to the Florida statutes. Count two. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanawa and or other persons to commit first-degree murder contrary to the Florida statutes.
There's
Count
room
three.
for others.
It is alleged
Chat,
that beginning in
room for others.
2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanawa and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markell, contrary to the Florida statutes.
And then they're going to, I imagine,
The
talk to the
statement
jurors
of the
one-to-one.
case and the indictment I have just read to you are not evidence and are not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. We are now going to talk to each of you individually and privately about this case. Some of you may be excused. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time consuming, but will go a lot smoother if you are prepared to tell us the information that we need
He's like,
to
it's
know.
like Rush.
These are the basic
Some of you will get your
questions
first
that will
choice.
be asked,
Some
or
of you will
some
go home
variation
disappointed.
thereof.
Some of you may be relieved.
What do you know about this case? What sources have you
Those
obtained this
5
knowledge
questions.
from?
What do you know? How do you
Based
know
on
it?
what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be a fair and impartial juror? Do you have any reason that you cannot serve on the jury for potentially up to 3 weeks?
And you'll notice he's looking to the side of him and kind of out into the courtroom. There would be 50 potential jurors that they're talking to all at once. So there would be some jurors seated in the jury box and then some seated in the rest of the open courtroom. So he's talking to a group of 50, not just the ones sitting in the jury box.
Will save us all a lot of time if you think about these
So
questions.
think about your
and
answers,
be
folks.
prepared to give us a prompt answer when you are called back. The last question that we will discuss with each of you individually deals with hardship. We expect the jury selection process to take until Thursday of this week. After that process is complete, we expect the trial to start on Friday and last for 2 weeks. All in total, we expect the proceedings from today will take up to 3 weeks. We understand that is a burden for anyone
Friday.
to serve for that length of time. However, we cannot make our system of justice work unless we have good people
Yeah,
that
can't
are
go
willing
faster.
to do their civic duty and serve as jurors. Similar to military service, we do have to call on our citizens to make sacrifices, and jury duty is one of those times. You will probably never be called on again to serve in a trial of this length and nature.
But it will be
However,
fascinating.
I
Y'all
understand
hang in
for
there.
some of you, service
Hang
in
in
this
there.
matter may not be possible under the circumstances. To give you a little more information about what this will involve, you will not be sequestered during this trial.
Yeah, you get to go home.
What that means is you will be able to go home as you normally would and return the next
You
day.
you can't be on
For the
socials.
most part, we will work a regular business day, but on occasion, it may become necessary for us to work a little bit longer based on the
Florida.
witness schedule. I will do my best to adhere to a regular schedule each day. So please give some thought to whether any of you may have a major problem, including a physical issue that would prevent you from giving this case your full attention for the time period in which we are discussing. Please be patient with us. We will be working as efficiently as we possibly can. The bailiffs, clerks, and court
Sometimes things will
administration
get
will be
off
assisting in
the
the courtroom.
rails.
Please follow the bailiffs or
We'll
clerk's
do our
instructions.
best.
Do not discuss this case while you're waiting here or anywhere
Yeah,
else
they're not
until you've actually
allowed to
been
talk.
excused. Do not read or listen to any media accounts on your phone or anywhere else until you've been excused. Also, you are not to speak to each other while you are waiting to be examined by the court
No
and the attorneys.
chatting.
You may read your phones. There are some magazines here available, provided as reading material.
What about books?
But ultimately, you are not to speak to your fellow prospective jurors. Again, you are not to seek out any information about this case, but you may silently either read your phones, read the reading material that has been provided,
Play Midas Merge.
or even if you want to, get some
Pokemon.
shut-eye,
Pokemon.
you don't start snoring, but you're not to speak to each other. Are there any questions about this before we
You
get
can
started?
nap. I mean, don't snore. You can shut your eyes.
Well, if the parties can't come to the jury room at this time,
No, they
we will
can't
get
even
set
small
up,
talk.
and then we will start summoning back each of the jurors.
They can close their eyes so long as they don't snore. They can be on their phones. They can't be on social media. They can't talk to each other at all. They are not supposed to be talking to each other. I would imagine they've had issues with that because not all courts do it that way. And then they just go back and question the jurors. Let's see if the court comes back onto the record at any point. Nope, I think they're done for the day, or at least done enough. So 3 weeks. Opening statements as soon as Friday, but they could be sooner if the jury gets picked sooner. We're going to do some Q&A. We've been streaming for just about 4 hours today. We're going to stream less tomorrow. If we don't have a jury, we might just wait on Thursday and stream Friday because I've got some travel coming up and I still am not unpacked from DCI, honestly. So EDB also needs to catch up on things. So it just depends on what's going on with jury selection and if we have a jury. If there's a jury sooner, I'm going to let you know in the Lawnerd app. If you are a new Lawnerd and commentary is for you, well, we've got you covered. And we've got the Lawnerd app. Free for you. It's on iOS and Android. LawnerdApp.com. We will notify you if we are going live outside of our regularly scheduled times, which, I mean, our regularly scheduled time is just like, ish. We still ish. It's like a concert. There's a start time and then there's a grace period. We got to let everyone get their snacks and get to their seats. So if a jury gets picked faster, the judge might start opening statements. If they've got a jury on Thursday by, noon, they will start with opening statements after lunch. The judge is not wasting any time. I will let you know in the Lawnerd app where we're at. And then at the end of the day, if it would be helpful, let me know, chat, if it would be helpful. At the end of the day, if it's helpful, I'll kind of let you know where the jury's at. They're not going to get any jurors picked today, but if they do, I'll let you know. So we are getting ready for the trial of Donna Adelson, which could start as early as Friday this week or earlier, or Monday, August 25th, 2025, on those 3 charges: murder, conspiracy to commit murder, and solicitation of murder. They are in the process of picking the jury. It actually started. They are in the middle of jury selection. And today yesterday, August 18th, the court ruled that the defense cannot subpoena Wendi Adelson, cannot have her testify, that she will be testifying for the prosecution under their subpoena, which grants her derivative and use immunity for the things that she testifies about in court. The defense can cross-examine her in the bounds of that direct examination, but they cannot call her separately to testify. Interesting to me is that the defense said, well, this is a different situation than prior trials because Donna Adelson is Wendi's mother, and there are different things she wants to ask. There is more that she knows. We've also heard the defense say clearly that Donna Adelson is going to testify. That will be once we get into the defense case in chief. I suspect we won't see Charlie Adelson, but who knows? And we also saw those motions about Jailhouse informants that were less redacted than last time, indicating that Donna had asked someone in custody to testify and was telling her what to say, which after going through the indictment again, where Charlie Adelson was telling Catherine McBanawell what to say, are we surprised? Yeah, I'm not either. So, Law Nerds, we are back in trial. It looks like we're going to need some work notes for everybody. We're going to be on East Coast time again. Trial's going to cover Pumpkin Spice Day, so we might have to start a little bit late. Emily got to go to Starbucks. We'll talk about it in the app. Don't worry, I'll keep you posted. So let's get to a few questions, and then we're going to bounce because we need to we have some stuff to do on our end with our new software, and we've got the rest of it. Casey Cat said Charlie has already been brought back to Tallahassee. He has. He is on hand if he needs to testify. It'll be interesting to see if he does or doesn't. He still has some appellate rights that haven't run yet, different than Catherine McBanawell. But yes, he's back in Tallahassee. So we'll see. Sam said, what do you wear for jury duty? I've wondered about it for a while. Well, on Law Nerd jury duty, Sam, whatever is comfy cozy for you. In court, it really depends on the courtroom. Some courts go with like a business casual. Some courts are cold, so people will wear jeans and like bring in a cardigan or a sweatshirt or a zip up. It really depends on the court, but society has gotten less formal. So I don't even know if everybody's in business casual, but just kind of a, jeans, shirt, sweater, if it's hot, or if it's cold in the courtroom. If it's hot in the courtroom, people might wear shorts if it is warm, depending on the trial. The judge is going to tell them to be comfortable. Kathy said, so they did 100 today out of 150. They called 300. They called in 2 groups of 50 today. So we will see. I don't know if they'll get through individual voir dire on all of them because some will get filtered out on the answers to the do you know about this case. There's already a report from local media from the Tallahassee Democrat that said that one of the jurors, because there's media in the courtroom, they're just not streaming jury, that indicated already that a few jurors have said that they know what this case is and they've made up their mind, but it's just a few who have said they heard of the case and already have an opinion about Donna Adelson's guilt. And everyone who indicated they had an opinion of guilt from the article I'm looking at said that they thought that she was guilty based on what they had seen in other trials, and including Charlie's trial and news reports. So they're going to call 300 total. They will get to, they'll get to however many they get to, because they'll go through that first group, 2 groups of 50 today, get rid of the people who already knew, and then start doing individual voir dire. And then the court can just start seating them. They might not need everybody. So we'll see. What else? Can we have a pajama day for court? Well, we can talk about it for sure. We can talk about a pajama day. Nancy says you're supposed to wear business casual. It really depends on the court. It really does. Some courts are a bit more formal, like jeans in federal court probably wouldn't fly. You'd probably want to see people in like, I don't know, dress pants, which for me, post 2020, I'd be like, so I have like jeans and leggings. That's all we got. That's it. I can do black jeans. That's about as formal as we have, but it really, really depends on jurisdiction. So depends on the court. Let me roll our FAQ, honestly, just because I want to make sure it rolls. So, I saw in the chat that Kimberly G NYC said not everybody wants to be on jury duty. I know, but it really depends. For some, a 3-week trial, especially if you work for yourself, you work in any type of service industry, 3 weeks without work could be a substantial hardship. It's also, I don't know if Florida schools have gone back. It's right at the beginning of the school year. If you are a teacher and you get called in to serve jury duty, like the first week of school, it seems like that would be just a nightmare because that's when you're like establishing all the rules. But also some teachers might be like, I'll be back. It just depends. But it's also a lot of work if you have to get like substitutes. If you're in the middle of a massive work project or you're in the middle of doing proposals or something, taking 3 weeks out at any particular time might be incredibly disruptive to your life. And for some, it might be like, it's fine. Let's do jury duty. We'll see. So jury selection is expected to go till Thursday with trial starting Friday. We'll see. So I don't know. We'll talk about a pajama day, maybe a robes day. However, half the clothes I have could honestly be pajamas, especially my big like Jedi hooded wrap that you know what I'm talking about. It is one of my favorite things to wear. That kind of covers as all things, but we can definitely do it. It'll be interesting to see if we start before Friday. For all of you that are members, thank you for your members chats. Some of our chats got yeeted. Again, we're always working on new things. So with new things come, new things, more money, more problems at this point. But for everyone who gifted memberships, including Sassy J in the UK, thank you so much. I appreciate it. Music to My Soul said, if only she wired money by drying it on the clothesline. It's a 10 out of 10 joke. It's a 10 out of 10 joke. Just wire it. Helena said, I bet she washed the stack of money equals moldy. Maybe she did. Maybe she washed it while it was still stapled. Yikes. That would have been interesting. Warrior River asked about DCI. Travis is a Cavalier and performed Shapeshift with the Cavaliers this year. We were at the back to school band event this week. I was talking to other parents and they're like, oh yeah, we were in Indy for finals last week. I'm like, it was last week? Like, it feels like it was 700 years ago, but also yesterday, and time is a construct, and I have no idea what's happening. I can't believe finals were just last weekend. I am still kind of reeling, and I have no sense of time. So yes, Cavaliers. It was a really fun show. I love the show this year. Let's see. Gossip, rumors, and innuendo. Emily, can there be YouTubers buying used, borrowed, your new streaming platform? Asking for myself. We're still rolling out all of our fixes. So we are still in like version 0.75. So down the road, I have no idea. But for now, we are still getting all of our solutions solved. And so we can't, we can solve our own, but I definitely can't customer service it for anybody else. So not yet, but we have been asked quite a lot. It is something I know is a problem. We are trying to come up with solves. It's more complicated than I anticipated. It's more complicated than we all anticipated, but we are trying to solve some unique problems. So we will see. But a lot of you have asked. So we'll see. Jason Fitz, thank you for the gifted memberships. Very much appreciate it. AKD said, I used to be a public defender and once had a juror tell the whole room that if they made him be on the jury, he would stand up at random times without notice and soil his pants. Quite a threat, it worked. I mean, of all the things you see in court, a juror being like, I'm just going to shit myself if you don't let me off of jury duty is quite a thing. It's just that's just quite a thing. And yes, that was my neck that cracked when I did that. It happens on occasion, but then again, I had friends in court when a defendant came into court with that in his pants and then hurled it at the judge. So that was a day. Defense attorneys put up with so much, just so much. Elisa, Emily, the new software or whatever it is so great. Thank you. We're excited. Look, I didn't realize how much compression there was from my end to y'all's end until we started switching things. I am so happy to be here and to have the team to help build out new solutions. It's just wild. Jason said in-house neurospicy legal counsel. In-house, you've made it, friend. Congratulations for the in-house gig. Sending love to my favorite community and giving thanks for the safe space and the analysis. None of the BS. Love y'all. We love it too. I mean, we will call things BS when they are, but yeah, we're not gonna overdo, and we're definitely not gonna call this something ridiculous. But you know, Donna Wet Money Adelson is kind of catchy. Kind of catchy. It really is. Donna Moldy Money. I can't help it. It's such a unique case when we know so much about it from the other cases that have gone before, and so many other people have already been convicted by jury. Whether there's enough to prove Donna did it will be interesting, but we will see. Cat Mom said, love the new streaming software. Wish the chats were a bit larger. It's already on our request list. So the font will be embiggened down the road. It's on the list. So yes, Amanda in the chat said Donna Musty Money. Donna Damp Dollars. Abby Robinson in the chat. We're going to have to vote on what we call the pickle. Damp Dollars is Donna Damp Dollars is really funny. Musty Money is just a 10 out of 10. Just Be Nice said, whoever thought of actually washing money as laundering? Donna. It tells you what you need to know, doesn't it? They also stapled it. It's such a strange thing. Lyndon with the Donna liquid assets. It's just so wild. It's and though the underlying crime in this case is incredibly sad. And the ridiculousness of what these people were doing was just so inept. But also, here, I think one of the things that frustrates me so much is that they were going through court process. And just because court doesn't go your way, look, hire different lawyers or whatever. Hiring a hitman is not the answer. Like, what are you doing? And in so many of the cases that we are covering lately, especially when we talk about like Corey Richins, we are looking at cases of marital discord that are ending in murder. It is not the way. And everyone says, you know, well, we wanted the kids to do this and we wanted the kids to do that. You know what you don't do is murder their father. That's not good for anyone's kids. That's not good for the kids. That this is not their father wanted to have them live close to him because he wanted to be an active part in raising his children. Okay, they can visit their grandparents in Florida. Their grandparents seem to be wealthy enough to go visit them in Tallahassee. You don't throw a temper tantrum and hire a hitman. Like, get a different lawyer. Stop it. Everybody says, you know, it's the kids. We wanted this for the kids. We wanted that for the kids. Kids kids want to grow up without their parents being dead. And that's hard enough when it happens under natural circumstances. I can only imagine it's way worse when they then have to watch their family members get convicted of killing their father. It pisses me off. So while I poke at, and I think more than probably other defendants, while I poke at Donna and Charlie Adelson for the ridiculousness of what they did, the rage is not so thinly veiled underneath that. And it's something I will mention as we go through it, because at the end of the day, there are quite a lot of families devastated by the rest of this. Michelle asked, if Wendi gets arrested, where do the children live? I don't know. I don't know. So I truly don't know. It's just it's incredibly frustrating. And again, with Corey Richins, Missy Lindy says, just like Corey Richins, with Corey, I'm going to poke at her stupid ass Google searches and the rest of it. We're going to watch and see how her trial plays out. We know quite a lot about it, but this is not good for the kids. Oh, someone's at the door. Well, Dr. B will be with you shortly. So with all of that, I mean, Dr. B did not return the call. I'm going to have to ask him and let you know. Law nerds, I will let you know what Dr. B has to say in the comments, but at over 4 hours, I've got to roll. Why? Because I've got to prep for tomorrow. We'll see if we talk about this more tomorrow. If anything happens, if not, we might catch up on some other cases. We might need to do a food court. So, but I heard Dr. B come downstairs. Let me see if I holler real quick if he'll come in here. I'm going to try. Hold on. Let's see if he heard me, since he doesn't hear his phone before we log off. See if I can. Nope. I hear nothing. I'll keep you posted. I'll let you know what he says. And then tomorrow, I haven't decided what we're covering tomorrow. If anything happens here, we'll probably cover this. If it doesn't, we'll just round up in some of the other things that are going on. There's a lot going on in Idaho. So, and we need a food court. I don't know when we have time to do a food court. We'll see. Maybe we'll do half and half tomorrow. Law nerds, you're the best. I'm going to roll the outro. We're going to see how it goes. And we'll see you back here tomorrow around about 11 a.m. So be sure to get the Law Nerd app. Thank you to today's stream sponsor, Incogni. Look, your information is all over the internet. Might as well save some money getting it taken off with Incogni. Let's roll the outro. Fingers crossed. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.